What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta, attorney, owner of Rekieta Law, a central Minnesota law firm. If you're ever in Minnesota, please give me a call. And I'd be happy to help out if you happen to run into any legal trouble. So today, we have some juicy stuff, and I will get to it in just a second. I'm just finishing setting up here. Let's see. Oh my goodness, guys. Hopefully the video is up. On my end, it's doing something weird. But let's get this moving. All right. Did I work on the Vizzini voice? Vincini. Maybe. Give me just a minute. Oh, chat window. Yes. Wrong chat. There we go. I apologize. 1 second, guys. I have to close this door because I can hear myself, and that's awkward. All right, that's entirely Lady Rackets' fault. And by her fault, I mean it's my fault, but I'm passing the blame to her. All right, guys. So, point of order. I have a couple super chats to address straight away. And so I'm going to do that first. The first one was well before the stream started. It was from Anna Ing. Late stream for me again. Can't blame you, though. Thanks for the content here. Buy some noodles with my Monopoly money, which I will happily do. Next was The Rafter with a shout out to Shug, S-U-G, and shout out to all my Shug homies. Keck7 Go says, I do not consent nor do I wish to create joinder with you, but you should shill your Patreon and tease the real law stories you recently published exclusively to your Patreonies. I will do that in just a moment. Kevin Flesher says, not going to be drinking tonight with you, buddy. Have a moto endurance race tomorrow. Here's to ya. Oh, man. Well, yeah, obviously don't drink if you've got a big race coming up. Stay safe out there. And when is the new Death Grips album coming out? From Ben Lanigan. I have no idea. And Nicholas Melchiori says, the cake is a lie. Fred Rush MD says, did Magnus do anything wrong? Magnus did nothing wrong. And at some point, we have to address the harshness of the Emperor's discipline. Gabraham Sandwich says, my body is Reggie. Just wanted you to know. Good. Mine too. All right, so to Keck7 Go's point, yes, Patreon. Patreon.com/lawsplaining. You can get access to all of this free content, obviously. You can also get access to audio versions from it in an RSS feed, if that suits your fancy. Of course, you can also get them from SoundCloud, Google, and, SoundCloud, Google, and what's the other one? Apple. Right? Apple. Podcasts. They have all of the audio versions of the content. Denise says Heather is effed. Absolutely. But I don't know if Denise properly put Heather in quotes so that we denote that Heather is just Maddox. Ben Lanigan says, Jamie, please. All right. Okay, so what Keck is talking about is there is a bunch of free content. All of this YouTube content, of course, is up on Patreon. But there is bonus content out there for Patreon subscribers once you hit the $5 and plus level. There is access to the Discord server, which we do live chats pretty much every Wednesday, where we just couple of us get around and whoever wants to chats, asks questions. The $10 level, you get to participate in the voice chat, which is great. And then there's the $20 level, which has a reward that's upcoming, which you get to watch me record the non-live stream videos, and that will be implemented very, very soon. So do check out the Patreon page, and if it's something you're interested in, please donate, or just drop a follow on there, even if you don't want to donate any money. Alan Foster says, have you gone to Pornhub to watch gun videos yet? I have not. I have not. That is great. Great news that there is still apparently a free speech platform, even though it would be something that many people would have to hide in their browser. Jesse Samuel Anderson also says Patreon/Asterios. And of course, we do encourage people to support Asterios Kokonos and Dick Masterson and anybody else attacked in this lawsuit, because it is not something that they should have to deal with. This is a free speech country. Get over that. And sometimes that means you're going to be made fun of, Maddox. But Maddox is not very good at dealing with criticism, nor commentary, nor anything he doesn't like, because he's basically an idiot. Okay, next point of order. I am drinking Hibiki tonight because I need to get through this bottle so I can justify buying more Japanese whiskey. Can't do that with some on my shelf. So that'll be nice. And then only album Maddox will make is a criminal record from the Shark Princess. Oh, okay. And that brings me to the final housekeeping bit before we get started, and we're going to hit these documents pretty hard once this last bit is done. And that is the newer format. It's now a couple live streams old, is in place today, where I will be reading through these documents straight away and only stopping really for live chats. I will not be interacting with tags in the chat during the document reading. The main reason for that is because it makes the viewing experience, or the listening experience, for people who are not able to make the live stream, it makes it much smoother for them. And I've gotten a ton of good feedback. It also lets me focus on the documents a little bit more and kind of get more and more angry. So I don't know if that's ultimately good for me, but it works better as a format. As always, I don't require any money to answer questions or interact with you guys. I love interacting with the chat. And so once the documents are done, there will be ample time at the end. So if you don't feel like doing a super chat tonight, perfectly understandable. Save your question, write it down if it comes to you, and bring it up at the end, and we will address it. And, I'll announce when there's open season on tagging, and we'll just go for it. All right, let's get started. Nicholas Melchiori says, State of New York, County of We Was Kangs. Okay. All right. So, I'm going to do this in filing order. I'm going to do this in filing order tonight. So the filing order, and we're going to skip a couple of the documents because they're old news. But the first filing order is the affirmation of Greenberger. The next is the notice of cross motion here. The next one that is relevant are the emails. And finally, we'll get into the memo. The other parts that I did not actually bring to the stream are the 4 prior affidavits of Azunian and the complaint and the letters exchanged by counsel, which we covered in the last live stream. Tester239 says, I appreciate your format. Thank you. Thanks, buddy. I appreciate you being here. Love having all of you guys in the chat. So let's go. Here we go. Affirmation of Jordan Greenberger. And that is, let's see. Hold on. Last things, making sure I'm not going to have a buzzing sound when my phone inevitably rings in a few minutes. All right. Jordan Greenberger, who is quickly inching up the short list. Not inching, actually. Leaping up the short list of people I really want to meet and buy a drink for. Jordan, if you happen to be watching this, man, I cannot wait to get the opportunity to meet you, because you seem like a pretty funny dude. An attorney duly admitted to practice before the courts of the state of New York affirms the following. So here we get a little insight into the life and practice of Jordan Greenberger. Oh my gosh. Okay. I forgot to talk about something on the Patreon, and I will do it that Keck mentioned, and I will do it at the end of the documents. But now we're in the documents, and we're in a different zone. So here we go. I am a solo practitioner operating through a single-member professional limited liability company, J. Greenberger PLLC. I represent defendant Asterios Kokkinos in the above captioned action and respectfully submit this affirmation in opposition to plaintiff's sanctions motion and in support of the accompanying cross motion for sanctions. So Greenberger is similar to me, single operation or single operator firm, and I respect that. Good job, buddy. Longneck McGee says beating Maddox's stream by over 250 GFY. Oh, Maddox. He needs to end his stream and come watch. That would be great. That would be better for him, I think. A better business move. Because inevitably after this stream, he's going to lose some subscribers. Plaintiff George is Orangutan. George Orangutan committed perjury and admitted to committing a crime against Mr. Kokkinos. And we're going with the YouTuber law pronunciation of Kokkinos. Criminal impersonation in the second degree. Let's see, Jamie Hughes says, I think Landau keeps repeating the plaintiff's typo because he defined Maddox and Jess that way in the first document and probably thinks he has to. That's very likely the case. What Landau should do, though, is he should learn to do what I've done, which is to read whatever he does and thinks is right and do the opposite. And I think that would make his career more successful. The Dresden 101 says, I am taking Corporate Law 301 this semester. Started watching your videos when the LoLsuit dropped and I started class January 2018. I have barely had to study thanks to you. Figured I should give you some of what I pay my professor. Thanks, buddy. I really appreciate it. And I am sorry that you have to take Corporate Law 301. Hope you make it through that class more awake than I would. When I notified Mr. Orangutan's counsel about the issue and reminded counsel of his ethical obligation to remediate his client's perjury, Mr. Orangutan's counsel quickly responded by attacking me, my client, and my client's fans like a rabid dog. Furious that I would not recant within hours, Mr. Orangutan's counsel filed off a sanctions motion against me. Plaintiff's sanctions motion is frivolous, but at least the motion brought Mr. Ozunian's conduct to the attention of the court. And it did. And it did. On March 8th, 2018, Mr. Orangutan executed and e-filed an affidavit in which he swore under oath that a year earlier, he pretended to be a Condé Nast journalist named, quote, Heather, end quote, and exchanged emails with Mr. Kokkinos' employer, defendant Weber Shanwick. These emails were intended to get Mr. Kokkinos fired and smear his reputation. The affidavit, a true and correct copy of which is annexed here too as Exhibit 1, directly contradicted Mr. Orangutan's allegations in the complaint, verified by him 4 times that he was not Heather. Fred Rush MD says, if you ever meet Greenberger, please buy him a drink with this super chat. Absolutely will do. Absolutely will do. And I have every intention of meeting him, even if it takes some sort of dramatic musical-esque Broadway story to get there. We are star-crossed attorneys, Jordan, and I will meet you someday. Mr. Orangutan's perjury. Before the March 8th affidavit, Mr. Orangutan repeatedly and under oath represented to the court and to the defendants that he was not Heather. In Mr. Orangutan's complaint, a copy of which is annexed here too as Exhibit 2, he denied that he was, quote, Heather, end quote. In 4 separate affidavits, copies of which without their accompanying exhibits are annexed here too as Exhibit 3, Mr. Orangutan swore under oath to having read the allegations in his complaint and verified them as true. He effectively verified the pleading. And that effective verification is effective. We should point that out. Like legally, he does verify the pleading. He attests to it under oath as to the best of his knowledge, a true and correct statement of the facts. And if anyone knew that George was lying about being Heather, I mean, you would think it would be George. Although maybe he was debating himself about whether he was Heather. And he lost, I guess. Plaintiff's March 8th affidavit, on the one hand, and his 4 prior affidavits on the other hand, cannot both be true. Paragraph 64 and 73 of the complaint, verified 4 times by Mr. Orangutan, directly contradicts his March 8th affidavit. In paragraph 64 of the complaint, Mr. Orangutan alleged and later verified 4 times, and every time he writes that parenthetical, know that he is smiling. That, quote, an individual named, quote, Heather, end quote, contacted various executives at Weber Shandwick by email in regards to a journalism piece she was doing about online trolls, bullying, and harassment, end quote. Emphasis added on an individual named Heather and she, because Maddox is apparently going for the full Spacey. Puma Pants says, congratulations, Landau, you cucked yourself. In other words, Mr. Orangutan swore that he was not, quote, Heather, end quote, because, quote, Heather, end quote, is a woman, she, and some other, quote, individual. But then in the March 8th affidavit, Mr. Orangutan swore under oath that he was in fact, quote, Heather, end quote. In the complaints, the next few paragraphs, 65 to 72, Mr. Orangutan alleges that there were several communications between, quote, Heather, end quote, and Weber Shandwick in which, quote, Heather, end quote, attempted to smear Mr. Kokinos' reputation with his employer and get him fired. Mr. Orangutan alleges that Weber Shandwick took no action against Mr. Kokinos following this exchange, and that when Mr. Kokinos learned about the quote Heather end quote communications, he posted about it online and demanded an apology from plaintiff. The quote Heather end quote allegations are material to Mr. Orangutan's allegations against Mr. Kokinos. Then, in paragraph 73 of the complaint, Mr. Orangutan alleged and later verified 4 times that Mr. Kokinos, quote, threatened to continue harassing plaintiff unless he apologized for something plaintiff didn't even do, which is emphasized. Der Commissar says, use this to buy the worst whiskey possible. I will apply it to the payment I already made for a tiny, comical bottle of Fireball. Maybe I'll send it to Maddox as consolation when he loses. In other words, Mr. Orangutan swore that there was nothing for him to apologize for because he did not send the quote Heather end quote emails, but then in the March 8th affidavit, Mr. Orangutan swore under oath that he was in fact quote Heather end quote. By swearing under oath 4 times that he was not, quote, Heather, end quote, and then swearing in the March 8th affidavit that he was, quote, Heather, end quote, Mr. Orangutan committed perjury. And I apologize for the quote, end quote on Heather, but I have to be clear that we're talking about the fictional, not fictional, that's a weird word that doesn't exist, the Heather that Maddox created. The issue is that Mr. Orangutan repeatedly swore under oath that he had not sent the quote Heather end quote emails, and then when it suited him, he turned around and swore under oath that he had sent the quote Heather end quote emails. Mr. Orangutan committed or attempted to commit a fraud on the court, and he absolutely did. And I think it's fair to say that Landau also, and I've said this before, and my blood pressure has skyrocketed from it, that Landau perpetrated the fraud on the court as well, because Landau is presumably the person who put the quotes around Heather. Landau knew, based on just logic, that Maddox was Heather. He had to have known. He put the quotes in there. Landau is complicit in the fraud on the court. I'm guessing that that's going to come up. I don't actually know if it does. But I'm guessing also the judge will put that together. Maybe. Who knows? And please remember, if you're tagging me in the chat, to save those questions for the end, and I will get to them. But otherwise, if you put them out there now, I will not be able to address them, and I will forget. Admission of criminal conduct. So this is the next subsection in the document. There are serious questions about Mr. Orangutan's credibility and sanity. And sanity was an addendum from me, sorry. But if Mr. Orangutan's March 8th affidavit is true, then in addition to perjury, he also admitted to criminal impersonation in the 2nd degree because Mr. Orangutan pretended to be a representative of the Condé Nast Media Organization and acted in such pretend capacity with intent to injure Mr. Kokinos, Penal Law Section 190.25, subsection 2. In the first email, quote, and Heather, end quote, identified herself as, quote, a freelance journalist writing on behalf of the Condé Nast Media Group, whose work has appeared in various publications. Oh, okay, there's a footnote that I skipped. Sorry. Footnote is see also paragraphs 138 and 141 of the complaint, which are part of Mr. Orangutan's defamation claim and allege that Mr. Kokinos' statements against plaintiff with false things, and that Mr. Kokinos' statements regarding plaintiff were, quote, were categorically false. And that is interesting, right? Because they were apparently categorically true, George. Der Commissar says, clarification, worst whiskey you'd actually drink. All right, buddy, I will do that, and I will be on a quest to find it. If anyone has suggestions, please let me know. The email then stated to Mr. Kokinos' employer that Mr. Kokinos, quote, is taking part in an online harassment and bullying campaign, end quote, is strongly prejudiced against women, uses alt-right terminology, and is using Weber Shandwick's resources to create harassing and bullying content. The email ended with a signature block which expressly identified Condé Nast Media Group, Condé Nast website twice, the address of the Condé Nast building in Times Square twice, one time with a typo. I mean, serious. Like, it's just the joy of needling, right? He is needling. And Condé Nast general telephone number, see Exhibit 1 here too at Exhibit A. In a subsequent email, February 25th, 2017, quote, Heather, end quote, stated that she was, quote, on assignment in London, implying she was doing work as a Condé Nast journalist, and included the same Condé Nast signature block. Weber Shandwick responded by requesting, quote, full contact details in the name of your editor at Condé Nast, and stating that, quote, as a professional journalist, I'm sure you understand that we need to verify the identity of any reporter. Gunsbeer Freedom 87 says, worst whiskey by far is military special. I'll have to see if I can find it. I will be on the lookout. Don't let me forget. In a subsequent email, March 2nd, 2017, quote, Heather, end quote, repeatedly referred to we, suggesting an association with Condé Nast, and again included the signature block. Javier Miedo says, you ever tried Buffalo Trace bourbon? I have not. Is it worthy? Is it worthy? I feel like I just read an article which listed it as like the best bourbon of 2018. I feel like I read that earlier today. Hatbuckle says you got to get a Fitbit blood pressure stat up in the streams like on TDS. Real Times Rackets rage meter for the win. That's a good idea. I'll have to talk to Mr. Masterson and find out how he has set that up and see if it's something I can implement, because that would be pretty funny. Let's see. The email also stated that the writer's intent was to hold Mr. Kokinos, quote, accountable for his, quote, illicit activities and to reach out to various advertising accounts with whom Mr. Kokinos had worked. It concluded, quote, I implore you to Google Asterios Kokinos and Dick Masterson to see what your employee is up to. You should be aware of the misogynistic nature of who you are employing. And wouldn't it be, to my grammar homies in the chat, wouldn't it be whom you are employing? He's talking about a proper name. I believe that's a whom. But, I'm not in full grammar mode yet. We'll see. Let me know if I'm right on that one. In sum, the quote, Heather, end quote emails were intended to smear Mr. Kokinos' professional reputation and get him fired. Even if Mr. Ozunian was not impersonating a real person, and then we go immediately. Oh, it's whomstative. Sorry, guys. I told you I'm not in full grammar mode. It's whomstative, and I apologize for that. On information and belief, there actually is a Heather S., quote, Heather S., end quote, who is employed by Condé Nast, and then it has a link to the LinkedIn profile, and she has been doxxed. So there's that. Kevin Flesher says, is that the 17-year Hibiki? I accidentally ordered 2 doubles of that in a bar where my friend said he'd pick up the tab. It was $260. I felt guilty. No, this is not the 17-year Hibiki. In my town, they only have the Hibiki Suntory blend. So this is the Japanese Harmony. Yeah, version. I am hoping to acquire a 17-year Hibiki. I've also gotten very favorable reviews of the Yamazaki, which I would like to try. The Yamazaki will probably be my next Japanese whiskey that I purchase. So, and Jared Bunnell, not Brunell. Jared Bunnell says, are Greenbergers keto? I think they would have to be. As long as there is a very thick bun. That would make them keto. All right. Okay, so he nonetheless pretended to be a representative of the Condé Nast organization and acted in such pretend capacity to injure Mr. Kokinos. So what Greenberger is doing here is important because the defense immediately alleged in Landau's motion is that Heather is not a real person and that is a crucial element of the criminal impersonation statute. Now, I have focused quite a bit on the fact that Heather S. is indeed a real person, and I think it is highly, highly suspicious that that they chose Heather S. specifically, and that there happens to be a Heather S. who is a content creator for Condé Nast, or a some sort of content creator. Anyway. So there is a plausible real person with a matching first name and initial. I think it'd be weird if they pulled that first name and initial combination out of the ether, and it just happened to match up, but maybe they did. Maybe divine providence is a thing that exists and has a great sense of humor against people like Maddox. But in any case, their first defense of this is that, well, that's not a real person. However, Greenberger is letting the court know that even if it's not a real person, they're still violating the statute. However, we believe it is a real person because there is such person, and he lets the court know there. Graham Laws says, ever had Royal Lochnagar? I had it in Scotland. Can't effing find it in the USA. Very good. I have not. But hopefully Lagavulin will sponsor me a trip out to the distillery when they get over the fact that I'm a degenerate. Ashen says, Greenbergers aren't keto, but they sure are kosher. I'll take your word for it, buddy. Mr. Kokinos' counsel... Oh, wait. Mr. Kokinos is a victim of Mr. Orangutan's crime, and he absolutely is. He absolutely is. It's important to note that Asterios is not necessarily out of the woods yet. Weber Shandwick has not fired him to this point, and I hope they continue to employ him because this is all nonsense, but it's entirely possible that they're merely waiting till the final resolution of this lawsuit to take employment action. And he has to be afraid of that. And even if they're not, and he's merely afraid and put into reasonable fear of this, then he is the victim of the crime, and they absolutely should step in and do something about it. Especially given this lawsuit. You know, maybe they wouldn't have the ability to do so for Maddox, who's in California normally, but by entering into this jurisdiction, entering into the venue and saying that it is the appropriate venue for litigating, he, in my opinion, has subjected himself to the rule of the court, and the court should take full advantage of that. Hatbuckle says, Keto mosquito goes skeet, skeet, skeeto. All right. And Duralia says, it's pronounced Coke in nose. You've been watching too much YouTuber Law. Yeah, I mentioned earlier that we're going with the YouTuber Law pronunciation just for fun tonight. And also because I really like Lior, and I need to get back to him on collaborating because I think we can put together some pretty fun content that both of our fan bases would enjoy. All right. Mr. Kokinos' counsel notifies Mr. Orangutan's counsel about the issue. After the March 8th affidavit was e-filed, I notified Mr. Orangutan's counsel, Mr. Landau, about the issue. In my letter, I respectfully requested that Mr. Landau, as an officer of the court and an attorney subject to the New York rules of professional practice, to be fair, Greenberger, I'm not sure Landau has actually read it. Take remedial steps. Shortly thereafter, Weber Shandwick's counsel sent a similar letter to Mr. Landau. We did not act in concert. Mr. Orangutan's counsel, Mr. Landau, quickly responded with a vitriolic letter demanding that I, quote, recant this nonsense and threatened to, quote, file a motion for contempt and sanctions. Given the short amount of time between my letter and Mr. Landau's response, it is unclear whether Mr. Landau even had a meaningful discussion with his client about the issue. Let's see. Pony Cordero says, Old Forester is a great cheapo bourbon. And Eddie Jefferson says, ever had rich... oh, aha, aha. I don't even know how to pronounce that without getting that clipped out. Good job, buddy. I'm not drinking enough to get caught by that one yet. Okay, let's see. I responded by notifying Mr. Landau that we disagreed with his response and would not recant. A true and correct copy of the correspondence is annexed hereto as Exhibit 4. It's important to note that Greenberger's letter was actually quite respectful, and the tone that he kept was professional. And like he says in the next point, the content and tone of the letters speak for themselves. And they really do. They really do. Landau was reacting in a way that was unbecoming, we'll say, of an officer of the court. And especially given the respectful letter sent by Greenberger to respond with vitriolic nonsense, just didn't. He went from 0 to 100 in the way that someone with, maybe alcohol in their system might do. I should not be sanctioned for informing Mr. Landau of the issues in a professional and respectful manner and requesting that he, as an officer of the court and in compliance with the rules of ethics governing lawyers, take remedial steps. I did not threaten Mr. Landau or plaintiffs. I note that I have been practicing civil law my entire legal career, and I am not, nor have I ever been or purported to be, a criminal prosecutor. Within hours of my reply, plaintiff filed a motion for sanctions against me and the PLLC through which I operate my practice. Ironically, by bringing the sanctions motion, Mr. Orangutan and his counsel complied with my request to disclose the issue to the court. And as noted by many of you, how's that for irony? Justin McInnes says, Heather S. is an anagram for shat here. Fantastic. Thank you for that. Mr. Orangutan's motion should be denied. Plaintiff is the one who committed perjury, admitted to criminal conduct, and his counsel refused to remediate the issue when it was brought to his attention. Plaintiff's motion for sanctions is in itself frivolous and a transparent attempt to distract the court from Mr. Orangutan's own misconduct. And that is obviously true. The Rafter says, omelets are pretty good, man. Yes, and so is the omelette du fromage episode of Dexter's Laboratory, which is all the French you really need. On the other hand, Mr. Coquinos' cross motion should be granted. Mr. Orangutan committed a fraud on the court and admitted to criminal conduct. He also brought a frivolous motion for sanctions. And it's important to note that this is not the first frivolous motion for sanctions filed by Kevin Landau. It is the third. It's the third. This hasn't even gone before a judge, and this dummy has filed for 3 sanction motions. 3. The first one was against Asterios for Landau's mistake on the rules of service when he thought that Asterios defaulted. And we'll get to that. Oh, okay, he didn't. Let me clarify that. I don't think he filed for sanctions on that one, but as we'll see in a minute, he asked for sanctions, or he asked for attorney's fees from Greenberger, which we'll get to. But then the next one was, of course, when he tried to put a restraining order on the entire earth for mentioning that he's a degenerate drunk driver who can't drive anymore because he continuously failed his intoxilizer that was placed on his car, the interlock ignition device. Like, he tried to stop people who have nothing to do with this lawsuit from saying Kevin Landau is overly drunk when he gets behind the wheel of a car, to the point where the state had to intervene for the safety of everyone else on earth. And then he has now brought another motion for sanctions in regards to his own screw-ups yet again. Absolutely terrible. Absolutely terrible. And Denise, you're right. This is a routine he does. I know I'm not supposed to watch the chat, but that just caught my attention. And we will have, some sanctions videos coming out. And we'll talk about, at some point in the future here, when I get a little time, if the spicy goss would stop for a minute, and I get time to do so, I will go through Landau's routine act of filing for sanctions in so many cases that it's just annoying. Anyway. And not being awarded them. Procedural matters. Mr. Kokinos has separately moved pursuant to CPLR 3211A7 to dismiss a complaint for failure to state a claim. That's motion sequence 001. Oral argument is scheduled for March 27th at 11 a.m. before Justice Ramos in Part 53. At the time I sent my first letter to Mr. Landau, the oral argument had not yet been scheduled. To comply with the timing requirements of the irregular CPLR Section 2214B notice in Mr. Landau's notice of motion, this cross motion is being filed/served before oral argument of the motion to dismiss. The outcome of that motion may impact the ultimate relief available to Mr. Kokinos on this cross motion, i.e. if the motion to dismiss for failure to state a claim is granted without leave to amend, then there is no need for the court to exercise its inherent authority to strike Mr. Orangutan's pleadings. Fred Rush MD says, please, yes, Spicy Moon sanction videos. That is going to happen. Lastly, annexed hereto as Exhibit 5 are emails that I exchanged with plaintiff's counsel after plaintiffs moved the clerk for a $20 million default judgment against Mr. Kokinos, premised upon plaintiff's misunderstanding of when service was, quote, complete under CPLR 3082. In one email, plaintiff's counsel stated that plaintiff would be willing to withdraw the default for reasonable attorney because it should be attorney's fee, and the cost of preparing and filing it in the amount of $2,545. Mr. Kokinos declined the invitation. The emails reflect plaintiff's pattern of sharp litigation practices and meritless demands for unsubstantiated legal fees. Vista says, so is Landau going to have to bike to New York City or what? That or Uber, I guess. Hope he doesn't get one of those Uber drivers who refuses to pick up someone who smells like alcohol. Okay, I lied earlier. I said we were going to go in order of the filing. So the next thing would be the cross motion, but I actually want to jump to the emails first, mainly because of this last paragraph. While it's fresh, let's tackle that and see what happens. Sorry. Okay, so I'm going to read these in reverse order because as it's an email chain, the lower email comes first. So this is an email from Zach Landau of the Landau Group. This is Kevin's brother, presumably. Aria says, can you get a DUI for drinking playing Mario Kart? Maybe if you do it in public. I don't know. That's a good question. I'm sure Landau will find a way. Hi, Mr. Greenberger. Hi. We are in receipt of your email. Kevin is tied up today in meetings, but advised me to promptly contact you in an attempt to resolve your concerns and provide you with our response. Adam Knowles says, I'll be in MSP for work on Wednesday, Thursday, and would love to buy you a drink. Let me know if that's cool with you. It is cool with me. I'm not sure if I will be in MSP on Wednesday, Thursday, but I will let you know. Find a way to message me either on Patreon or on Facebook or on Twitter, and we can talk about it. Okay. On November 14th, 2017, Mr. Kokinos sent a tweet from his Twitter page to over 11,000 of his followers, admitting service of plaintiff's summons and complaint upon him, and even attached a full picture of the summons and indicated, what's got two thumbs and is getting sued by Maddox rules? This guy. Further, Mr. Kokinos asked his followers to, quote, contribute to the Asterios Kokinos legal defense. Moreover, Mr. Kokinos posted another tweet on November 15th explaining that a, quote, YouTube copyright attorney at Leonard J. French would be talking, quote, about Maddox's $20 million lawsuit against us on the episode of the Lawful Masses. Asterios, I'm kind of offended that you didn't tweet about mine because then Landau would have had to write my name in an email. But I will allow Leonard French his moment in the sun. Said tweets are attached here too for your review and were annexed to plaintiff's default. Clearly, the foregoing tweets constitute an admission of service under CPLR 306E and adequate proof of service. No, they don't. Notwithstanding the foregoing, and in the spirit of cooperation, plaintiff would be willing to withdraw the default for reasonable attorney's fees and the cost of preparing and filing it in the amount of $2,545. Thanks, Zach. Let's talk about that. Guys, you are asking for the court to decide on default judgment for $20 million. You are asking the court to say, no matter what Asterios does from this point on, nothing he can do. You're asking for a final judgment on default for $20 million. And then Asterios would have a massive burden to justify defaulting on something. And in Landau's mind, in Landau's plural mind, Landau's minds, although maybe they only add up to one, I don't know. They've stated that he failed their personal service. That he failed to respond to personal service in a timely manner. So they're saying they win, but they're willing to forego their automatic victory of $20 million for $2,545. Garbage. This is extortion. It's unprofessional. It's unbecoming. Zach, you should be ashamed because I was actually giving you credit when your brother was a complete tool. And that's disgusting. But we can revel in this assumption. When you ask for attorney's fees, at least in my state, when you ask for attorney's fees, the understanding and the rules of practice dictate that you are asking for fees actually incurred. Not like some pretend amount of fees. So if there's a New York lawyer who wants to correct me on that, maybe their rules of practice are different. I don't know. But in Minnesota, he would be saying that he actually billed Maddox $2,545 to file a default, which was based on a factual error by the attorney. And that is refreshing. That he had to withdraw. He had to withdraw that because he was so ridiculously incorrect. He had to withdraw that. So, good job. Good job, Landau group. Fleecing Maddox. If for nothing else, I hope you charged Maddox the $2,500 for your own screw up, and I hope he paid it because all of you are terrible. And I hope he sues you for it. Maddox, if you're watching, maybe you should look into the quality of your representation and see if they're following the ethical rules that they have sworn to competently represent you, because you may have a claim at this point. Especially if they advised you to lie under oath, especially if they advised you to admit to perjury under oath. Oh my God. And especially if they are charging you fees for for a motion that they filed based on their own factual error. May want to talk to a different attorney. Fred Rush MD says, what is 20 million in sneaky Greek dollars? Based on the Greek economy, I think it's pretty much a sandwich. All right, so Jordan responds. Mr. Greenberger, let's be respectful to him. Mr. Greenberger responds, Zach, thank you for responding. I was hoping to first discuss on the phone, at the very least, to introduce myself. If you would prefer to communicate by email, that is fine too. My client will not be paying the requested amount. Obviously. There has been no default under CPLR, and in any event, I expect the application will be denied as inappropriate for CPLR 3215A relief from the clerk. Because again, he asked this from the clerk, not from the judge, and a $20 million default award from the clerk is a little suspect. I urge you to reconsider your position, not only because of the CPLR, which again, they got wrong, but also because of the misstatement in paragraph 8 of the moving affidavit that Mr. Kokinos was personally served. You are also no doubt aware of the court's desire to resolve cases on the merits and the absence of any prejudice to plaintiffs. That being said, if a judgment is entered, Mr. Kokinos reserves the right to seek his attorney's fees and costs from plaintiffs in any motion to vacate. So he's got a couple arguments here, and let's go. Oh no! Is it back? Is it back? Okay. Good. Sorry, I actually had the chat window hovering over my quality of the bitrate monitor, so I apologize for that hiccup. I blame country internet. All right, so Greenberger has a couple. He has a couple different arguments going on in this final paragraph, and let's go through them real quick. So first is the CPLR that he mentions, and that is where service becomes effective after you personally serve the person and file, or you personally serve and file, or after you serve in an alternative method to personal service, like service upon an employer, which is what happened for Asterios. And then you file, and then an additional 10 days, and then they have 30 days to respond from there, if I remember the rule correctly. So that's the CPLR argument, but also because of the misstatement in paragraph 8 of the moving affidavit that Mr. Kokinos was personally served. He was not personally served. He was served through his employer, and therefore, that is, and I will note that the notary stamp was expired, but whatever. Mr. Kokinos was personally served. That's a misstatement in the affidavit, and the affidavit is under oath. So that's a problem. And then finally, he's talking about the court's desire to resolve cases on the merits. A $20 million case, a court is going to be very hesitant to issue a default judgment, and especially if the responding party shows a good faith reason why they were in default, like we believe they were wrong about the facts of the service and that service wasn't actually effective at that point. And then they serve their answer in a reasonable amount of time after that, after it's brought to the court's attention. The court's probably not going to award $20 million because it doesn't harm the plaintiffs, especially when there are several other defendants who were still awaiting the return of service at that point, and several unserved defendants as well due to incompetence. Grant Mooney says, do you ever get too drunk and refer to yourself as Rekieta? If I was that drunk, I don't know if I would know. So anyway, so that's the emails here, and you can see that the lack of professionalism, at least in my opinion, extends not just from Kevin, but also to Zach. They're attempting to fleece Asterios out of $2,545 for no reason. Hopefully, they got that from Maddox and charged him for it, mainly because I want to see Maddox lose, although I don't want to see the Landau group enriched at all. So, all right, on to the cross motion. On to the cross motion. That's good. All right. Please take notice that upon the affirmation of Jordan Greenberger, dated March 23, 2018, with exhibits and the accompanying memorandum of law, defendant Asterios Kokinos will cross-move the court in room 130 of the courthouse located at 60 Center Street, New York, on the 2nd day of April 2018 at 9:30 a.m. So I guess the 9:30 p.m. in the Landau motion was inaccurate, or as soon thereafter as counsel may be heard, for an order pursuant to the court's inherent power and 22 NYCRR sections 130-1.1. And the order will do as follows. Striking plaintiff's complaint for having committed a fraud on the court, if not otherwise dismissed with prejudice for failure to state a claim, motion sequence 001. B, imposing financial sanctions upon both plaintiffs and their counsel for of record for 1, having repeatedly asserted material factual statements that are false, 2, refusing to remediate those falsehoods once given the notice and opportunity to do so, and then instead 3, responding by bringing a frivolous sanctions motion against Mr. Kokinos' counsel. C. Awarding Mr. Kokinos his costs and reasonable attorney's fees resulting from plaintiff's frivolous conduct, including without limitation those incurred by Mr. Kokinos in bringing this cross motion and his motion to dismiss for failure to state a claim, the amount to be determined at a hearing scheduled by the court. D. Referring plaintiff George Orangutan to the New York County District Attorney for having 1. Committed perjury, Penal Law Article 210, and 2. Admitted in his March 8, 2018 affidavit to criminal impersonation in the second degree, Penal Law Section 190.25 subsection 2, and E. For such other and further relief as the court deems just. Please take further notice that pursuant to CPLR 2214B, plaintiff's answering papers, if any, shall be served on the undersigned at least 1 day before the return date of this cross motion. So April 1st. And Landau may try, but the just kidding defense will not be sufficient for anything submitted on that date. So that's the notice of cross motion, and now we have the memorandum in support of cross motion. In support of defendants, cross motion for sanctions, and finally the defense is coming out with guns blazing in the appropriate manner for the ridiculous conduct of the plaintiffs. Table of contents. Preliminary statement, background and relevant facts. The court should strike plaintiff's complaint because plaintiffs committed a fraud on the court. Plaintiffs should be sanctioned under Uniform Rule 130-1 because they A. asserted material factual statements that are false, B. brought a frivolous sanctions motion which should be denied because Mr. Kokinos and his counsel did not act frivolously, C. the court should impose financial sanctions upon plaintiffs and their counsel and award Mr. Kokinos his costs and reasonable attorney's fees, and D. plaintiff sanctions motion should be denied for public policy reasons. Subsection 5, Mr. Ozunian should be referred to the district attorney, and then the conclusion. So let's go through it. Table of authorities. Ooh, we get some ethics opinions. Good job. Defendant Asterios Kokinos, by his undersigned counsel, respectfully submits this memorandum of law in support of the accompanying cross motion for sanctions, and in opposition to plaintiff's motion for sanctions against Mr. Kokinos' undersigned counsel in the maximum amount of $10,000 and alleged attorney's fees of $7,500. In attorney's fees against Asterios alone, Maddox has apparently incurred $10,000 in fees because he hired the most expensive and least effectual law firm I have ever heard of. Fred Rush, MD, is there a circumstance where you can deploy a Roman candle, bullhorn, cheerleader, banner, mascot, etc. when submitting a motion to the court? Yeah, I think if you do it outside the court, but loud enough that it would catch notice of the judge inside. All right. I am going to have a brief moment. And I'm going to shout out to Keck for sending me this jury. That's going to be the next glass of whiskey I have tonight. And we'll see how that goes. It is an unaged whiskey, which is partly why it's clear, and that is why it's clear. It hasn't taken on any color from any wood. It is a harsh whiskey, but it is pretty good. I'll say it grows on you very quickly. All right. Cheers, buddy. Okay. So yes, $10,000 in attorney's fees just against Kokinos alone. At this point, you can assume Maddox's bill is through the proverbial roof. Plaintiff sanctions motion is the definition of chutzpah and should be denied. And Mr. Kokinos' cross motion for sanctions and other relief, including referring Mr. Orangutan to the district attorney's office, should be granted. Preliminary statement. Plaintiff George Orangutan committed a fraud on the court and admitted in an affidavit to criminal conduct. Now, he and his counsel have doubled down and moved for sanctions against Mr. Kokinos' undersigned lawyer for having the audacity to request that plaintiff's counsel take steps to remediate the issue. The court should strike plaintiff's complaint if it is not otherwise dismissed for failure to state a claim, and impose financial sanctions against plaintiffs for having committed perjury and then engaging in frivolous litigation, citing CDR Creances SAS versus Cohen. And, let's see, the 22 NYCRR sections 130-1.1. Lucifer Love Monkey says, use this for Iron Maiden's Peace of Mind album. Okay, buddy. Will do. Will do. I will download it tonight. The court should also refer Mr. Orangutan to the district attorney for prosecution and award Mr. Kokinos his costs and reasonable attorney's fees of the action. Puma Pants says, can Landau's chutzpah be seen from space? At this point, I think so. Hopefully, this is the new mission I have, is to get this one of these live streams broadcast directly to someone up in space. Maybe Tesla can make it happen. Or I mean, I should say not Tesla. Tesla's dead. Maybe Elon Musk can make it happen in one of his rocket launches. Mr. Orangutan has repeatedly and under oath represented to the court and to the defendants that he was not the female Condé Nast reporter named, quote, Heather, end quote, who sent emails to Mr. Kokinos' employer, defendant Weber Shandwick, in an attempt to get Mr. Kokinos fired. And I think Maddox needs some severe shame from the trans community for appropriating trans identity in doing this. And I bet if I make another Google video and mention a few of their employees' names, I could maybe get their attention long enough for them to go full bore against Mr. Orangutan for his hateful appropriation of their identity without undergoing any of the struggles that trans people go through every day. And that is disgusting and offensive to me, and I think he should be shamed for it. Gargle Bucket says, use this for Iron Maiden's Power Slave album. It's better than Peace of Mind by $1. Sounds good. Will do. Will do. My kids will get an education about awesome metal music when I add the Iron Maiden albums to our playlist that we use while driving long distances. Okay. The allegations, verified 4 times by Mr. Orangutan, are material to Mr. Orangutan's claim that Mr. Kokinos posted online about the emails demanding an apology. As alleged by Mr. Orangutan in paragraph 73 of the complaint, which he has repeatedly said under oath that he read and verified as true, Mr. Kokinos threatened, quote, to continue harassing plaintiff unless he apologized for something plaintiff didn't even do. Elsewhere, Mr. Orangutan described Mr. Kokinos' statements, including those accusing Mr. Orangutan as being, quote, Heather, end quote, as categorically false. In other words, Mr. Orangutan repeatedly denied that he was Heather. Quote, Heather, end quote, sorry. Then, in opposition to Weber Shandwick's motion to dismiss, Mr. Orangutan executed, served, and filed an affidavit in which he stated that he had, in fact, sent the quote, Heather, end quote, emails. Greenberger, Affirmation, Exhibit 1. Mr. Orangutan's admission that he was, quote, Heather, end quote, is completely contradictory to the previous sworn statements. Mr. Orangutan is not credible. But if his latest affidavit is to be believed, then in addition to perjury, he also admitted to criminal impersonation in the second degree. Mr. Orangutan pretended to be a representative of the Condé Nast Media Organization, and he acted in such pretend capacity with intent to injure Mr. Kokinos. Mr. Kokinos is the victim of a crime. Mr. Kokinos, he left off the apostrophe. Undersigned counsel brought the issue of Mr. Orangutan's contradictory testimony and admission of a crime to the attention of Mr. Orangutan's counsel. There were no threats of criminal prosecution, and that is important, even though I think maybe mentioning threatening to bring this to a district attorney, not in exchange for dismissal, because that was never done, but I think just simply threatening to do it is permissible under the rules, so long as you're not doing it solely for the purpose of gaining an advantage in court. But notifying them that they intend to pursue criminal action, I don't know if that's actually a violation of the rules. Jesse Samuel Anderson, will dismissal and sanctions impact Dick's case? It is possible. That's a very good question. It is possible that dismissal due to the fraud perpetrated on the court could amount to an automatic dismissal of Dick's case as well. It's possible. It's not necessarily the way things have to go down. They may just determine that it prejudices Asterios. I think it prejudices every single defendant, and the case should be dismissed on that, and of course all of the other grounds previously mentioned. But yes, sanctions will not impact Dick's case. The only way that sanctions would impact Dick's case is if Dick was also awarded some sort of attorney fee, or if the sanctions applied to Dick and they became, more money than Maddox would have available, then maybe he wouldn't be able to pay everybody as much as he should. So, it would just kind of maybe water down some award that Dick would be given, not under force of law, but under force of Maddox's failure to properly monetize his content over the past 2 decades. Matt Claremont Davies says, Nick Rekieta LoLsuit is an anagram of I eat troll cucks. See? Yes. I'll take your word for it. I love it, though. Yes, Maddox and Jess. That is important. Jess is on here, hopefully. Jess is some sort of trust fund trade show model and has just gobs of money sitting around that she has been supporting Maddox with as he has, moved closer and closer to the poverty line. And that any sanctions against Maddox should similarly apply to Jess. They are, well, I don't know if they will necessarily, but the court should do that. The court should do that. They shouldn't automatically attach because they're not married, which may save Jess a bunch of money. But since they are co-plaintiffs and closely related in this action, and their actions are often in tandem, I think the court should apply sanctions to both of them, not just to Maddox. But there is a possibility that it would go that way. All right. In fact, there were no threats at all. Plaintiff's counsel was merely advised that if he did not remediate the issue of his client's perjury, as he is required to do by the rules of professional conduct and as an officer of the court, quote, then we intend to take the appropriate steps to notify the court ourselves. The letter speaks for itself. Greenberger, Affirmation Exhibit 4. By bringing the motion for sanctions, ironically, plaintiff's counsel actually has brought the issue to the attention of the court. However, he did it in the whiniest, slap-fightiest way I can imagine. Mr. Orangutan's counsel had and has an ethical obligation to take remedial measures. See Rule 3.3A3 and B of the New York Rules of Professional Conduct. Also, ethics opinions interpreting the rule, including NYSBA Ethics Opinion 837, NYSBA Ethics Opinion 980, NYSBA Ethics Opinion 1123, NYCLA Ethics Opinion 741, and ABCNY Ethics Opinion 2013-2. And Uniform Rule 130-1.1 also prohibits frivolous conduct, which includes asserting material, factual statements that are false and bringing sanctions motions which themselves are frivolous. The burden is on Mr. Orangutan's counsel to remediate material falsehoods that are presented to the court by his client. Mr. Orangutan's counsel, who should be especially sensitive to issues involving false testimony, given his own recent experience representing a client who was sanctioned for pressing allegations that she knew to be false, Almasiga versus Center for Investigative Reporting Incorporated, was given an opportunity to remediate the situation, and that, my friends, is brutal. Alan Foster says Landwee's argument to this is the equivalent to "know you," and that is the most appropriate summary of Landau's arguments. Know you. Mr. Orangutan's counsel, however, doubled down, just as he often does at the bar before getting behind the wheel of a motor vehicle. The vitriolic content and tone of his letter and subsequent motion for sanctions speaks for itself. Hours after Mr. Kokinos' undersigned counsel informed Mr. Ozunian's counsel that we, quote, respectfully disagree and would, quote, not be complying with your demand to recant. Plaintiff shot from the hip and brought a motion for sanctions. The motion seeks $10,000 against Mr. Kokinos' undersigned counsel, as well as an alleged $7,500 in attorney's fees. The claim for attorney's fees is wholly unsubstantiated, and this is now the second time that plaintiffs have demanded attorney's fees for their baseless motions. Footnote 1. Plaintiffs made a baseless CPLR 3215A motion to the clerk for a $20 million default judgment against Mr. Kokinos, premised solely on plaintiff's complete misunderstanding of when service was, quote, complete under CPLR 3082. When Mr. Kokinos brought this to the attention of plaintiff's counsel, they responded, quote, in the spirit of cooperation, plaintiff would be willing to withdraw the default for a reasonable attorney sick fee and the costs of preparing and filing it in the amount of $2,545. See Greenberger Affirmation Exhibit 5. Mr. Kokinos declined the invitation. that's one way to say it. What's up, Sev? Welcome. That's one way to say it, is declined the invitation. Mr. Orangutan committed a fraud on the court and then responded by claiming that Mr. Kokinos' lawyer did something inappropriate. Chutzpah. At least Mr. Orangutan's counsel has now brought the issue of his client's perjury and apparent admission of criminal liability to the court's attention. Fred Rush, MD, I quote, Mr. Ozunian's counsel quickly responded by attacking me, my client, and my client's fans like a rabid dog. Raging Hot Truth says, how the F did Landau pass the bar in the first place? Let me roll back for just a minute. Bar passage is obviously critical for becoming an attorney, a licensed attorney. But I will say that bar passage is not an indication of who will be an effective attorney. It is not. Some very, very effective attorneys failed their bar exams multiple times before passing. You know, some people aren't good at taking tests, and that is an exam that is tailored towards people who are good at taking tests. Ben Lanigan says, legality behind butt farming. I don't know. I'd have to consult Sean and see if he has consulted any counsel at this point and what they have said, but I assume it would be state specific. So back to the bar question. You know, I will note that I passed the bar on my first attempt. I'm a good test taker. So that was fine for me, but there are people who did not pass the bar who end up being very good attorneys, and there are many people who do pass the bar on their first attempt who end up being garbage. I have no idea how many attempts Mr. Landau took to pass the bar, but what I do know is after passing one, he never failed to pass another. Sorry. I couldn't resist. All right. Okay, back to the document. Thank you for the digression. Landau is wicked smart. All right. At least Mr. Orangutan's counsel has now brought the issue of his client's perjury and apparent admission of criminal liability to the court's attention. Plaintiff's motion is itself frivolous and warrants monetary sanctions, including awarding Mr. Kokinos his attorney's fees. Mr. Kokinos has separately moved to dismiss the complaint for failure to state a claim. Motion sequence 001. If that motion is not fully granted, then the court should strike plaintiff's claim for having committed perjury. The court should refer Mr. Orangutan to the New York County District Attorney for criminal prosecution, both for perjury and criminal impersonation, and impose financial sanctions upon him. How the court addresses Mr. Landau's conduct, we leave to the court's discretion. However, Mr. Kokinos should be awarded his costs and reasonable attorney's fees, both for these sanctions motions and for having to bring a motion to dismiss a complaint which asserted material, factual statements that are false. Absolutely, he should. Absolutely. And Asterios, buddy, if you get awarded this and there's some magical world where Maddox has enough money to pay you, I hope you put that money to fantastic use. Producing quality content as you have been doing for a while now. And I hope all of the defendants are reimbursed their ridiculous fees in this case and are able to use that reimbursement to continue producing good content for their fans. Background and relevant facts. Plaintiffs are suing Mr. Kokinos for the absurd amount of $20 million and have also sued Mr. Kokinos' employer, defendant Weber Shandwick, in a transparent attempt to retaliate against Mr. Kokinos and get him fired. It has not worked, and as explained in Mr. Kokinos' CPLR 3211A7 motion to dismiss, plaintiffs failed to state a claim and should not be granted leave to amend motion sequence 001. Ben Lanigan says, you should get a pop filter for your mic, please. I have one on here. Sorry, I'm just that loud. I apologize. Maybe I'm too close. On at least 4 occasions, Mr. Azunian executed and filed affidavits stating that he has read the complaint and verified the allegations as true. These include the complaint's allegations about an individual named, quote, Heather, end quote, who identified herself as a Condé Nast reporter, and Mr. Azunian's denials that he was, quote, Heather, end quote. On March 8th, 2018, plaintiffs filed an affidavit executed by Mr. Orangutan in which he admitted that he posed as, quote, Heather, end quote. The affidavit contradicts Mr. Orangutan's previously verified allegations. In the affidavit, Mr. Orangutan also admits to criminal impersonation in the second degree. Props to Greenberger for a proper use of semicolon, something that Landau has never done so far in this lawsuit. Mr. Kokinos' through counsel. Oh, buddy, that's a weird apostrophe. Jared Bunnell says, when he loses, can the judge order Maddox to sell his AIDS meds, his AIDS meds to pay Asterios' legal fees? I guess he would have to order him to get licensed as a controlled substances dealer in the state of California to do so first, but I don't see why not. So in the affidavit, Mr. Orangutan also admits to criminal impersonation in the second degree. Mr. Kokinos, apostrophe, through counsel, brought this to the attention of plaintiff's counsel. These sanctions motions followed. The court is respectfully... here's what happened here. I'm going to apologize for Greenberger's inappropriate apostrophe because he's my dude. He originally... probably wrote, Mr. Kokinos' counsel brought this to the attention of plaintiff's counsel, read that, thought maybe it would be better to add the comma through counsel and just forgot to take off the apostrophe. That makes complete sense. These sanctions motions followed. The court is respectfully directed to the accompanying affirmation of Jordan Greenberger for a further statement of the facts and the procedural posture. The court should strike plaintiff's complaint because plaintiffs committed a fraud on the court. Maybe it is an Easter egg apostrophe. There you go. If not dismissed with prejudice for failure to state a claim, then the court should exercise its inherent authority to strike the complaint because plaintiffs have committed a fraud on the court. Citing CDR Creance's SAS versus Cohen. Quote, where a court finds by clear and convincing evidence conduct that constitutes fraud on the court may impose sanctions including, as in this case, striking pleadings and entering default judgment against the offending parties to ensure the continuing integrity of our judicial system. As explained by the Court of Appeals, fraud on the court involves willful conduct that is deceitful and obstructionistic, which injects misrepresentations and false information into the judicial process so serious that it undermines the integrity of the proceeding. It strikes a discordant chord and threatens the integrity of the legal system as a whole, constituting a wrong against the institution set up to protect and safeguard the public. Accordingly, quote, fraud on the court warrants heavy sanctions, including the striking of an offending party's pleadings and dismissal of the action. Here, Mr. Orangutan repeatedly lied to the court. On 4 occasions, he stated under oath in connection with pending motions that he had read the complaint's allegations about, quote, Heather, end quote, and how he was not, quote, Heather, end quote, and that the allegations were true. Then, when it suited him, he submitted an affidavit stating that he was, quote, Heather, end quote. The affidavits are clear and convincing evidence of a fraud on the court. Clear and convincing evidence is a legal standard. It is somewhere above reasonable suspicion and somewhere below beyond a reasonable doubt. So there you go. It is a very precise term. But no, it's a high standard. It is not the lowest standard. It is not more likely than not. More likely than not is 51%. Clear and convincing evidence is probably around the area of 70% certainty. Beyond any reasonable doubt is 99.9, percent certainty. So clear and convincing evidence, 75%, but just know that that's a legal term of art, and it is a standard the court has laid out pretty heavily. There's lots of literature about what clear and convincing evidence is. The quote Heather end quote emails are central to Mr. Orangutan's claims against Mr. Kokinos and Weber Shandwick in the complaint. There is no plausible explanation why Mr. Orangutan first stated under oath that he was not quote Heather end quote, and then later stated under oath that he was quote Heather end quote. Mr. Azunian has knowingly attempted to hinder the court's fair adjudication of this case and Mr. Kokinos' defense of the action. IT Weeb says, could Asterios seize Maddox's assets to pay his attorney, including his half of the biggest problem in the universe and the Maddox brand itself? That is a possible outcome. The most likely way in which that would happen would be through a negotiated settlement after attorney's fees are awarded. If Maddox were to give up the brand of the biggest problem in the universe or any of Maddox's other property, intellectual property. I hate saying intellectual in accordance with Maddox, but if he were to agree to give up any of his intellectual property in exchange for, monetary sanctions, so he could continue living next to his homeless hippie neighbor, that would be a possibility. The other possibility, and I'm not sure on this, but under New York or California collection law, whichever is more appropriate, assuming Asterios is awarded some sort of fee, it's possible that the collection law would allow them to levy various assets of Maddox. And if Maddox doesn't own real things, because as far as I can tell, he rents an apartment with like 14 other people, attempting to recreate the Duggar family, but only more degenerate, and doesn't appear to own much of anything. I don't think he has a car. He has a bike, from what I can tell. It seems like you could potentially levy the intellectual property, as that might be the only thing Maddox owns of value other than various cricket caltrops so he can afford to eat. But who knows? Who knows? I'm not familiar with the levy laws in California or New York enough to make a definitive statement on whether his intellectual property would be suspect. Kellen Miller says, how can you pass the bar but not realize you are incriminating yourself and your client? Also, Jeb Bush should have won. Think of the memes. That would be the best reason for Jeb to win. Would be the memes. But yes, passing the bar. So the real question is how Landau passed the professional responsibility ethics exam. Is the multi-state bar exam is roughly 200 questions, multiple choice, and most of them have nothing to do with the with professional responsibility, and like this incriminating question would be maybe in there, but not likely. Maybe I should do a video talking about the bar exam sometime, and telling people how to pass it. It's if you know how. It's a tough exam, but it's not that bad. But a lot of people, I think, focus their efforts in the wrong places. Anyway, I would say that, the real concerning question is how he passed a professional responsibility exam and doesn't know this stuff, because that is where these questions are more likely to arise. Okay. Mr. Orangutan has knowingly attempted to hinder the court's fair adjudication of the case and Mr. Kokinos' defense of the action. If the complaint is not otherwise dismissed for failure to state a claim, then the court, in its inherent authority, should strike plaintiff's complaint for, quote, when a party lies to the court and is its adversary intentionally, repeatedly, and about issues central to the truth-finding process, it can fairly be said that the party has forfeited the right to have the claim decided on the merits. Not insignificantly, plaintiffs and their counsel did not attempt to correct their misconduct when brought to their attention. Instead, plaintiffs went on the attack like a rabid dog. Plaintiffs should be sanctioned under Uniform Rule 130.1 or 130-1. Plaintiffs should be sanctioned for having asserted material factual statements, and then, when the lack of factual basis was brought to the attention of plaintiffs' counsel, for having made a frivolous motion for sanctions rather than remediating the issue. Mr. Kokinos should be awarded his costs in the form of reimbursement for actual expenses reasonably incurred and reasonable attorney's fees resulting from plaintiffs' frivolous conduct. In addition to or in lieu of awarding costs, the court, in its discretion, should impose financial sanctions upon plaintiffs and their counsel for having engaged in frivolous conduct. Under Uniform Rule 130-1.1c, defines a frivolous, oh my goodness, guys. Defines frivolous conduct as, inter alia, among other things, conduct that, quote, is undertaken primarily to delay or prolong the resolution of the litigation or to harass or maliciously injure another, or that, quote, asserts material factual statements that are false. Additionally, frivolous conduct includes the making of a frivolous motion for costs or sanctions under this section. In determining whether the conduct undertaken was frivolous, Uniform Rule 130-1 instructs the court to, quote, consider, among other issues in the circumstances under which the conduct took place, including the time available for investigating the legal or factual basis of the conduct, and whether or not the conduct was continued when its lack of legal or factual basis was apparent, should have been apparent, or was brought to the attention of counsel or the party. So he gave him a way out. Gave him a way out of the sanctions. Didn't take it. Plaintiffs asserted material factual statements that are false. Before the affidavit, Mr. Azunian repeatedly and under oath represented to the court and to the defendants that he was not, quote, Heather, end quote. He denied that he was, quote, Heather, end quote, in the complaint and in 4 subsequent affidavits. Mr. Azunian swore under oath to having read the allegations in his complaint and verified them as true. He effectively verified the pleading. The affidavit, on the one hand, has the 4... and his 4 prior affidavits, on the other hand, cannot both be true. And that paragraph looks exceedingly familiar. Paragraph 64 and 73 of the complaint, verified 4 times by Mr. Orangutan, directly contradict the affidavit. In paragraph 64 of the complaint, Mr. Orangutan alleged and later verified 4 times that an individual named Heather contacted various executives at Weber Shandwick by email in regards to a journalism piece she was doing about online trolls, bullying, and harassment. In other words, Mr. Azunian swore that he was not quote, Heather, end quote, because, quote, Heather, end quote, is a woman, she, and some other, quote, individual. But then, in the affidavit, Mr. Orangutan swore under oath that he was, in fact, quote, Heather, end quote. This is a repeat of the affirmation. In the complaint's next few paragraphs, Mr. Orangutan alleges that there were several communications between, quote, Heather, end quote, and Weber Shandwick in which, quote, Heather, end quote, attempted to smear Mr. Kokinos' reputation with his employer and get him fired. Mr. Orangutan alleges that Weber Shandwick took no action against Mr. Kokinos following this exchange, and that when Mr. Kokinos learned about the, quote, Heather, end quote, communications, he posted about it online and demanded an apology from plaintiff. The, quote, Heather, end quote, allegations are material to Mr. Orangutan's allegations against Mr. Kokinos. Then, in paragraph 73 of the complaint, Mr. Orangutan alleged and later verified 4 times that Mr. Kokinos, quote, threatened to continue harassing plaintiff unless he apologized for something plaintiff didn't even do. In other words, Mr. Orangutan swore that there was nothing for him to apologize for because he did not send the, quote, Heather, end quote, emails. But then in the affidavit, Mr. Orangutan swore under oath that he was in fact, quote, Heather, end quote. By swearing under oath 4 times that he was not, quote, Heather, end quote, and then swearing in the affidavit that he was, quote, Heather, end quote, Mr. Orangutan committed perjury. The issue is not whether Mr. Kokinos or any of the other defendants suspected that Mr. Orangutan had sent the, quote, Heather, end quote, emails. The issue is that Mr. Orangutan repeatedly swore under oath that he had not sent the Heather emails, and that and then when it suited him, he turned around and swore under oath that he had sent the, quote, Heather, end quote, emails. Mr. Orangutan committed or attempted to commit a fraud on the court. I am not caught in a loop, but this complaint is, or this petition is. Motion. Plaintiffs brought a frivolous sanction motion, which should be denied because Mr. Kokinos and his counsel did not act frivolously. Quote, an attorney's duty to zealously represent a client is circumscribed, not circumcised, y'all. Get your mind out of the gutter. By an equally solemn duty to comply with the law and the standards of professional conduct to prevent and disclose frauds upon the court. To that end, the rules of professional conduct expressly prohibit an attorney from, among other things, making a false statement of fact or law to a tribunal, offering or using evidence that he or she knows to be false, suppressing any evidence that he or she or the client has a legal obligation to reveal or produce, knowingly using perjured testimony or false evidence, or otherwise knowingly engaging in other illegal conduct. Yannick S. versus Frederick T. In short, when perjured testimony is offered, the party's lawyer has an obligation to do something about it. See People versus DiPaolo and in R.E. Radman. Suspending lawyer from practice of law who had offered evidence that the lawyer knew to be false. Again, I will say that Landau knew that this was false. That's why he put the quotes around Heather, and he should be sanctioned for it. His law practice or license may need to be... His law license in New York should probably be suspended anyway, but also for this. After the affidavit was e-filed, Mr. Kokinos' counsel notified Mr. Orangutan's counsel, Mr. Landau, about the issue and respectfully requested Mr. Landau take remedial steps pursuant to counsel's ethical obligations. Mr. Kokinos' counsel's letter stated that if plaintiffs did not remediate this issue, then Mr. Kokinos' counsel intended to take steps to notify the court. Shortly thereafter, Weber Shandwick's counsel sent a similar letter to Mr. Landau. There were no threats of prosecution designed to harass plaintiffs into submission. The only thing Mr. Kokinos' counsel did was ask plaintiffs' counsel to comply with his ethical obligations, and if he did not, then Mr. Kokinos would take steps to remediate the issue, especially because there was a pending motion to dismiss for failure to state a claim that concerned in part the quote Heather end quote allegations. Plaintiffs cite Jalor Color, but that case is easily distinguishable because the attorney, a former assistant district attorney, made post-trial, quote, threats of criminal prosecution as part of a, quote, calculated deliberate strategy designed to harass plaintiffs into folding its litigation hand. There were no threats of criminal prosecution here, and Mr. Kokinos' counsel is not a former prosecutor. Thank you very much, Chris Howell, for the super chat donation. Mr. Kokinos was not seeking to accomplish by threats and intimidation what he was otherwise unable to accomplish in the litigation. Parenthetical, oral argument of his motion to dismiss had not yet even been scheduled when the initial letter was sent, and this cross motion is being filed before oral argument of the motion to dismiss. Nor did Mr. Kokinos threaten to saddle plaintiffs with criminal liability. Neither the language nor the import and tenor of Mr. Kokinos' counsel's letter conveyed a bold impression that should plaintiffs refuse, then Mr. Kokinos and his counsel would wreak havoc upon plaintiffs. And he's citing that Jalor Color case. He's referring directly to language from that case. If there was an ultimatum at all, it was not criminal prosecution, but notifying the court about the issue. But here's the rub. That's a great line in the middle of a legal document. But here's the rub. Plaintiff's counsel had an ethical obligation to notify the court himself! Exclamation point! Thanks, Raging Hot Truth, for the donation. I really appreciate it, guys. Mr. Kokinos' counsel's letter was premised upon Rule 3.3A3 and B of the New York Rules of Professional Conduct. Footnote, plaintiff's counsel was also referred to related ethics opinions interpreting the rule supra. Above. Up there. Earlier. Incorporated in all of this. Rule 3.3 of the Rules of Professional Practice provide in pertinent part. A lawyers shall not knowingly offer or use evidence that the lawyer knows to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. B. A lawyer who represents a client before a tribunal and who knows that a person intends to engage, is engaging, or has engaged in criminal or fraudulent conduct related to the proceeding shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. Official comments 10 and 11 to Rule 3.3 provide. So this is the fun part of lawyer rules of conduct, is you get these rules, which are right here, And then you get a whole litany of official comments which clarify the rules and are very complicated. Jason Benaim says, is it normal for people to get caught perjuring themselves in a court case? If this is how every court case is, then this is bonkers, but what do I know? No. I mean, yes, people do get caught perjuring themselves in court cases. It is not normal to do so. And there is nothing normal about this case. I have expressed from the beginning that or at least I think so. At this point, I'm starting to question my own sanity. I've expressed from the beginning that I believe this is such a unique case in that it is so ludicrous as to be, it merits being brought in law schools and on how not to act, and maybe even on how to deal with unreasonable representation of the other party. Because so far, all of the defendants' counsels have taken different approaches to dealing with the fragile personality that is Landau, and they've all done so in a professional manner, which is commendable. Because if I were their counsel, I would be really aching to throw hands. Not that I would, but man, dealing with this idiot would be infuriating. Okay, so comment 10, a lawyer who has offered or used material evidence in the belief that it was true may subsequently come to know that the evidence is false. Or a lawyer may be surprised when the lawyer's client or another witness called by the lawyer offers testimony the lawyer knows to be false, either during the lawyer's direct examination or in response to cross-examination by the opposing lawyer. In such situations, or if the lawyer knows of the falsity of testimony elicited from the client during a deposition, the lawyer must take reasonable remedial measures. The advocate's proper course is to remonstrate with the client confidentially, advise the client of the lawyer's duty of candor to the tribunal, and seek the client's cooperation with respect to the withdrawal or correction of the false statements or evidence. If that fails, the advocate must take further remedial action. If withdrawal from the representation is not permitted or will not undo the effect of the false evidence, the advocate must make such disclosure to the tribunal as is reasonably necessary to remedy the situation, even if doing so requires a lawyer to reveal confidential information that otherwise would be protected by Rule 1.6. And that would be attorney-client privilege, I believe. I'm not familiar with the rules of professional conduct by number without referencing them, but I'm going to guess that that's attorney-client privilege. It is for the tribunal then to determine what should be done, such as making a statement about the matter to the trier of fact, ordering a mistrial, taking other appropriate steps, or doing nothing. Number 11, the disclosure of a client's false testimony can result in grave consequences to the client, including not only a sense of betrayal, but also loss of the case and perhaps a prosecution for perjury. But the alternative is for the lawyer to cooperate in deceiving the court, thereby subverting the truth-finding process, which the adversary system is designed to implement. See Rule 1.2d. Furthermore, unless it is clearly understood that the lawyer will act upon the duty to disclose the existence of false evidence, the client can simply reject the lawyer's advice to reveal the false evidence and insist that the lawyer keep silent. The client could therefore, in effect, coerce the lawyer into being a party to a fraud on the court. And you don't want to commit fraud on the court. That can get you disbarred. Mr. Orangutan's counsel, Mr. Landau, quickly responded with a vitriolic letter demanding that Mr. Kokinos' counsel, quote, recant this nonsense, and threatening to, quote, file a motion for contempt and sanctions. Given the short amount of time between the initial letter and Mr. Landau's response, it is unclear whether Mr. Landau even had a meaningful discussion with his client about the issue. Mr. Kokinos' counsel responded by notifying Mr. Landau that he disagreed with his response and would not recant. The content and tone of the letter speak for themselves. Within hours of Mr. Kokinos' counsel's reply, plaintiff filed a motion for sanctions against Mr. Kokinos' counsel. Ironically, by bringing the sanctions motion, Mr. Azunian and his counsel disclosed the issues to the court. Plaintiff's barking sanctions motion is frivolous and should be denied. Plaintiff is the one who committed perjury, admitted to criminal conduct, and his counsel refused to remediate the issue when it was brought to his attention. C. Yenum Corp. versus 155 Wooster Street Incorporated. Sanctions imposed where plaintiff's attorney rejected defendant's counsel's request to remediate frivolous conduct. Plaintiff's motion for sanctions is itself frivolous and subjects him and his counsel to sanctions. That's Turkjack versus Turkjack. I don't know how to pronounce Turkjack. Sanctions imposed upon counsel for making frivolous motions for sanctions. Plaintiff's response to Mr. Kokinos' letter is especially troubling, considering Mr. Landau's own recent experience representing a client who was sanctioned for having committed a fraud on the court, Almasiga. Their attempt to portray Mr. Kokinos and his counsel as having engaged in sharp practices, when it is actually plaintiffs who have engaged in sharp practices, has but one purpose: to obscure the issue of Mr. Orangutan's own misconduct. The court should impose financial sanctions upon plaintiffs and their counsel and award Mr. Kokinos his costs and reasonable attorney's fees. The sanctions against plaintiffs and their counsel should be as follows: a financial sanction and awarding Mr. Kokinos his costs and reasonable attorney's fees resulting from plaintiff's frivolous conduct, including without limitations those incurred in bringing this cross motion and Mr. Kokinos' motion to dismiss for failure to state a claim. Uniform Rule 130-1.1a. The amount of Mr. Kokinos' costs and attorney's fees will be established at a hearing. Gatsgat says, I just drove 10 hours. The last hour and a half I did at 1:30 after getting the alert on my phone to get here for this. #apostrophe. Well, thanks, buddy. I appreciate you risking your safety. Since you're a Canadian, I will assume that 130 is in kilometers and translates roughly to 60 miles an hour, and therefore you are probably not recklessly driving. I got your back, buddy. Okay. As to imposing financial sanctions, the court may award up to $10,000, quote, for any single occurrence of frivolous conduct. Uniform Rule 130-1.2. Here, there were multiple occurrences of frivolous conduct. Plaintiff sanctions motion. The, quote, Heather, end quote, allegations in the complaint. The 4 affidavits verifying the truth of the allegations. Plaintiff's opposition to Mr. Kokinos' motion to dismiss for failure to state a claim, to the extent the opposition relied upon the, quote, Heather, end quote, allegations, and plaintiff's response to Mr. Kokinos' letter concerning the, quote, Heather, end quote, and criminal impersonation issues. I think also there's another one. The frivolous conduct would be the motion to dismiss. I think he left that out personally, but, you know, maybe not. Plaintiff sanction motion should be denied for public policy reasons. Plaintiff sanction motion should also be denied for reasons of public policy. A lawyer should be encouraged to bring to the attention of his or her adversary in a professional, civil, and non-threatening manner, like here, issues that arise in litigation concerning the court's truth-finding function. When material falsehoods are presented to the court, an attorney should not fear being sanctioned for bringing the issue to the attention of his or her adversary, who has an ethical obligation to remediate the issue. If the court were to grant plaintiff sanction motions, then it would have a chilling effect. Lawyers should not be discouraged from identifying and attempting to remediate perjury and the admission of criminal conduct. Bookham Dano says, I just recklessly drove home 50 miles at ludicrous speeds to watch this. I appreciate that. And only because I see it. No, I have never spoken to Mr. Greenberger, and I would refuse speaking to Mr. Greenberger until after the termination of this action. As I would refuse speaking to Matz or Munoz or anyone else, although I do hope to, when this action is over, interview many, if not all, of the attorneys involved. Whoever would be willing to talk to me, I think we would do great to have some postmortems on this and get their perspectives on the case, and if they've encountered anything like this before, that would be great. Gats, I'm not supposed to respond to the chat, but I was trying to help you. Avoid any sort of criminal liability. But what can I do? I can only do so much. Mr. Azunian should be referred to the district attorney. Mr. Kokinos is the victim of a crime. The court, in its inherent authority, should refer to Mr. Orangutan to the district attorney for prosecution, e.g. River Bay Corp. Versus Houston. Referring witness to district attorney's office so that it could conduct an appropriate investigation whether to prosecute the witness for perjury and any other offense. Nicholas Melchiori says, interview Landau, whatever has to be done. Oh my goodness. Mr. Ozunian has committed perjury and admitted to criminal impersonation in the second degree. Having submitted wholly contradictory sworn statements, there are serious questions about Mr. Ozunian's credibility, but if the Heather affidavit is true, then in addition to perjury, he has also admitted to criminal impersonation because Mr. Orangutan pretended to be a representative of the Condé Nast media organization and acted in such pretend capacity with intent to injure Mr. Kokinos. Penal Law 190.25 provides in pertinent part that a person is guilty of criminal impersonation in the second degree when he, 1, impersonates another and doesn't act in such assumed character with intent to obtain a benefit or injure or defraud another, and 2, pretends to be a representative of some person or organization and doesn't act in such pretended capacity with intent to obtain a benefit or to injure or defraud another. In the first email, quote, Heather, end quote, identifies herself as a, quote, a freelance journalist writing on behalf of the Condé Nast Media Group, whose work has appeared in various publications. The email then stated to Mr. Kokinos' employer that Mr. Kokinos is taking part in an online harassment and bullying campaign, is strongly prejudiced against women, uses alt-right terminology, and is using Weber Shandwick's resources to create harassing and bullying content. Cuck. There's some alt-right terminology for you. The email ended with a signature block which expressly identified Condé Nast Media Group, Condé Nast website twice, the address of the Condé Nast building in Times Square twice, one time with a typo, Tims Square, and Condé Nast general telephone number. In a subsequent email, quote Heather, end quote, stated that she was, quote, on assignment in London and implying she was doing work as a Condé Nast journalist and included the same Condé Nast signature block. Weber Shandwick responded that by requesting full contact details and the name of your editor at Condé Nast and stating that, quote, as a professional journalist, I'm sure you understand that we need to verify the identity of any reporter. In a subsequent email, quote Heather, end quote, repeatedly referred to we, suggesting an association with Condé Nast, and again included the signature block. The email also stated that the writer's intent was to hold Mr. Kokinos, quote, accountable for his, quote, illicit activities, and to reach out to various advertising accounts with whom Mr. Kokinos had worked. It concluded, quote, I implore you to Google Asterios Kokinos and Dick Masterson to see what your employee is up to. You should be aware of the misogynistic nature of who you are employing. Whom? You're a journalist. You're a journalist, Maddox. Whomstead, Pony Cordero, all we have to do is leak that Landau has information that will lead to Hillary Clinton's arrest. No, it can now be clipped out of context. Landau, be safe, friend. In sum, the quote Heather, end quote, emails were intended to smear Mr. Kokinos' professional reputation and get him fired, even if Mr. Orangutan was not impersonating a real person, as is required for prosecution under Subdivision 1 of the criminal statute. Although, footnote, on information and belief, there actually is a Heather S. who's employed at Condé Nast, and they have Miss Heather Semler's LinkedIn profile. Do not bother her or email her. My personal recommendation, which is not legal in any sense, is leave that poor woman alone to write all sorts of articles that you'll probably never want to read. Fred Rush MD says it's Coke and O's. We're going with Kokinos today, buddy. Kokinos. Mr. Orangutan, nonetheless, pretended to be a representative of the Condé Nast organization and acted in such pretend capacity to injure Mr. Kokinos. That is a violation of Subdivision 2 of the criminal statute, and Mr. Kokinos is a victim of Mr. Ozunian's crime. Conclusion, plaintiff's motion for sanctions, sequence 006, should be denied, and Mr. Kokinos' cross motion should be granted. Done, finito, that is the document list for today. And it was good. And Greenberger looked over all that he had written, and it was good. It was very good. So, what are we to do next? Let me go back to the very beginning. And my good friend Keck7Go has reminded me at the very beginning of this to shill the Patreon, which is patreon.com/Lawsplaining. We're hovering right around the $800 a month mark, for which I am immensely grateful to you all. And I hope to continue to provide quality content that you guys enjoy and are happy to donate for. And if I'm not providing the kind of content that you are happy to donate for, please let me know. I'm happy to also take constructive criticism, as I have done from day one, and tailor my product towards an audience that wants to purchase it. And let me tell you guys, I will get to these tags in just a moment. But Keck mentioned one other thing that I forgot to mention earlier, is that there is bonus content. I mentioned the Discord and the live chats that we do, but there are also two mini sort of sub-series that I do. One is Bedtime Stories from Based Americans, which is where I read inspirational or otherwise hilarious literature from American speakers, writers, politicians that I find particularly enlightening, inspirational, or fun. And I do it in a bedtime story voice for you guys. The other one, and I need to do some more of those because I like them, but I need to find some more inspirational material for them. The other thing that I do is Real Law Stories, in which I talk about personal experiences in the law that maybe people outside of the legal profession wouldn't have much knowledge of things that, how things work, or there's a particularly novel legal issue that I dealt with. And I just tell a nice real law. It's impossible for me to say law without lol these days. Tell a nice story in a very calm and anti-ragey sort of way. And I hope that people who consume that content really likes it. So yes, now that is said, we are on to the point where I will answer tags. Of course, you can still super chat me to your heart's content. I will never turn down super chats from any of you guys, but I will now answer. Kokinos is driving me nuts. Yes. Sorry, real SG125. I will now answer tags, and I will try and keep up. So, any thoughts on the Count Dankula case, my dude? Yes, I have many thoughts on the Count Dankula case. I think it's absolutely revolting that he would be charged and in the first place, much less convicted for making a joke. And it's important to note, guys, that if you go back and watch that video, Count Dankula specifically states that he is turning the whatchamacallit. He is turning the pug, which his girlfriend says is too cute, to the least cute thing he can imagine, which is a Nazi. So the UK has criminalized the fact that the saying that Nazis are uncute. So you must say that Nazis are cute in the UK to be compliant with the Communications Act. Also, Gats tells me to plug my subreddit to you Luddite. Well, that was hurtful. Yes, there is a Lawsplaining subreddit. It is, reddit.com/r/Lawsplaining. I don't know how that works. Yes. Go check it out, subscribe, participate. All of the announcements of videos and live streams do show up there. And if you have any questions for me, that's a great place to reach me. As for the thoughts on Count Dankula, I think it's horrifically offensive that he was charged with anything. That he was convicted is worse. And I am actually hoping to gather the documents if I can get my hands on whatever. I'm not super familiar with the UK court system, but I am hoping to gather the documents and do a Euro-friendly live stream, which will be at a different time, friendly to the European audience, and hopefully we can have a good discussion about the Count Dankula case, and I will probably burst some blood vessels. I love you too, Dax Desi. Thanks for always being in the streams. I really appreciate it. Clay Early says, can I get a cheers off you, my man? Of course, buddy. Thanks for joining. I know you had some stuff going on earlier in the evening, and I'm glad that you were able to come on when you got done with that. Let me pour just a tiny bit more Hibiki for myself so I can properly cheers you. Let's see. Okay, what do you think about the gun control debate? Do you own a gun? Yes, I own several guns, and I think my honest thought of the gun control debate is let's have a debate. Let's go ahead and do that, but let's get something very clear first. We have a Second Amendment that states that the right to keep and bear arms shall not be infringed. And we have been infringing it since 1934 with the passage of the National Firearms Act, which is offensive to me. And if you want to have a debate, about what we should do with guns, it's got to start with changing the amendment. And we have to decide as a nation if the amendment is good enough as is or if it needs to be changed. There's a super chat in here. Let's see. Justin Brodak says, what would it take to prosecute Asterios as a sneaky Greek for a non-sneaky friend? I think we'd have to extradite him to Greece to do that. Oh, Clay. Cheers, my man. My dude, fam. Let's see. Is there anything Greenberger left out that you would have included? There was one part where he mentioned the $10,000 per instance, and he left out the frivolous motion to dismiss from that. Although he mentioned it earlier, I don't think there's much that he left out here that I would have included. It's very thorough, and he kept it down to only about 16 pages of text, which was polite of him to do so. I can't think of anything specific. I might have hammered more on the fact that there's a real Heather S., but at that point you're starting to get into a lengthy document for no reason. So I think it's good. Pony, I will rant about Dankula, but I want to save it for that live stream. More Disney songs. I need Lady Rackets for that, and I don't know if she's in the mood to come on the stream tonight. Why George decided to confess being Heather? That is a great question. I bet he did it on advice of counsel, because Landau's like, look, man, you need to do this. And I think maybe it was Landau protecting himself, and I think maybe he was doing that to prevent his own sanctions, to try and head off sanctions against him, and basically say, well, my client did this, and make it look like he didn't know from the beginning. I don't know if that's true. I don't know that that's true, but that's the feeling that I get from it. Yeah, so we'll see. Clay, I'm going to give you a face tattoo. You enjoyed the real law story. Good. Thank you. I'm glad you did. I really, really hope people enjoy those. And I like to give an alternative view of what lawyers do, and helping out people who are, in really rough situations. And Harry Balls 089, I addressed the gun control thing comment earlier, but you added another thing about it being unconstitutional. Check out my video on the Florida lawsuit from the NRA, and that I think I discussed the constitutionality. If you have more questions about that, send me personal messages and we can talk about it. If Landweeb takes you to court for defamation, are you going to argue that it's your opinion, or are you going to go to court to prove that he's an incompetent moron? I think both. Both. It's my opinion that he's an incompetent moron, but the court should take judicial notice that he is clearly an incompetent moron. If Landweeb has brought a lawsuit, does that mean he is a lawyer? I think so. The documents refer to Heather as Heather and not Heather S. Why is that? I don't know. I think in the original complaint, it's Heather, and Heather S. comes up somewhere else. I can't remember exactly where Heather S. comes up. Oh, well, Heather S. is just in the email. And maybe that... I hate to give them credit of forethought, but maybe they were trying to head off the idea of actual impersonation. You trained your cats to be a Nazi. That probably wasn't a hard job. I think cats are inherently Nazi fascists. If Landweeb is disbarred in New York, can he practice in a different state? Asking for my friend Jack me off. Yeah, he should still be able to practice in Michigan, although they may take notice of his disbarment. But the bars of each state would be the ones to determine the registration of an attorney. So if he was disbarred in New York, if the state of Michigan took notice of it and then decided his activity in New York was egregious enough to disbar him in Michigan, they could potentially do so. Does Landau have to respond to this? You never have to respond to a motion. You should always respond to a motion, but you never have to. Is it just going to bury his case even more than it is now, or do you think he will play it safe at this point? I think he will respond. I think he will triple down. I think he will triple down and go for it. Are you in need of a lit support specialist? Like, are you talking about someone who is a specialist in being lit, like lit AF? If so, yes. Are you talking literary support specialist, literature support specialist? Please clarify. Would you want to do a video on expunging a misdemeanor conviction on my record? It comes with a hilarious backstory. Sure, buddy. Send me a private message and we'll talk about how we can work on that. All right. Okay, answered the guns questions. Are we going to laugh at sovereigns today? Maybe. Let me get through some of these questions here. We need to remove Second Amendment. It's un-American. Okay. I don't necessarily agree with that. Doesn't the Second Amendment mention regulation in the first sentence? Why are gun control laws unconstitutional? That's a good question. So the Second Amendment says, let's see, a well-regulated militia being necessary for the security of a free society, the right of the people to keep and bear arms shall not be infringed. Something pretty close to that. So the well-regulated militia is, according to Scalia, is a prefatory clause. And what that does is it just sort of sets up the right. This is a reason that the right exists. It is not the sole reason the right exists, but it is a reason the right exists. And it's important to note that at the time of the passage of the Second Amendment, the well-regulated militia would consist of every able-bodied male between the ages of 15 and 45 years old, and they would all be expected to own and carry their own firearms. So when they showed up for their they would have like a monthly training session where they would get together with the other members of the militia, which again was everybody, and they would go through some drills to act as some sort of coherent unit. They would be expected to bring their own firearm, and if they were called to act in defense of their town or in defense of their state, then they would similarly be expected to bring their own firearms, as the state did not own a ton of firearms. Most of the munitions used in the early days of our country were privately owned, including cannons and including warships. Is being cuck a constitutional right? Is being cuck a constitutional right for pirate? Sure. Yes, you have a constitutional right to be a cuck. So why are gun control laws unconstitutional? Because of the statement, the right to keep and bear arms shall not be infringed. So anything that infringes on the general population's right to keep and bear arms is an impermissible infringement on the Second Amendment under the plain language of the amendment. And that is how we treat every other instance of shall not be infringed. First Amendment infringement is very specific and has an extremely high bar of review. Second Amendment restrictions have lately not gotten that same deference. Didn't get to catch the live vid, but I'll watch later, so keep on keeping on, I guess. Thanks, buddy. What is the best Monopoly playing piece and why is it the car? Oh, because cars are awesome. That's it. Any way we can form a dickhead militia? Yes. Does Landau have to respond to this? So if I didn't answer that, he doesn't have to respond to this, but you always should. What do you think about gun content moving to Pornhub? Of anything I can think it's a good business move. Absolutely. I mean, if you don't have a platform on YouTube, you go to somewhere else, and a place that is known for hosting adult content and potentially offensive material to the sensitive among people, that is a great place to host it, as long as they're fine hosting it on their platform. Are both Maddox and Jess responsible for sanctions related to this, or just Maddox? I'm saying both. They're both plaintiffs in this, and they're close enough in relation to the facts that they should both be held. How can I go higher than Greater Rift 103 in Diablo? I'm doing a Leap Quake Barb this season. I don't know, man. I've never pushed that far on the Greater Rift thing, mainly because I don't play well with others on Diablo. What are your thoughts on the Pitch Perfect movies and why do you hate them? I like the first one. The second one was pretty cringy, and I haven't seen the third one yet. But I really like what's her face, the main actress, and I like the dude that they have as the main male protagonist too. What do you think about Ruby Ridge, Waco, and Oklahoma City? Ruby Ridge and Waco are just atrocities of government intervention. Man. Buff G Bob, how bad do you have to F up to get disbarred? Pretty bad. But usually, getting disbarred involves an intentional act of being a complete turd. So usually you're intentionally screwing over your client or failing some massive ethical obligation intentionally. Otherwise, what they do is they will suspend your license for a period of time or maybe even have you rehabilitate with another attorney. Eric Blum, I notice you, buddy. What is the best anime and why is it Girls Unpanzer? I've never watched that. I am partial to Evangelion. I like Gurren Lagann. Dragon Ball Z and Super are fun. They're not great, but they're fun. Love you too, Clay. How angry and incoherent will Landau's response be, and how early in the morning will he turn it in? Soon. Did you watch the photocopier case yet? No, I don't think so. Unless you're talking about the Rick and Morty thing. Yes. My brain is kind of fuzzy at this moment. All right. If Motion 001 passes, is Asteroid still on the hook for Motion 006? Will he be paying for it? Asking for Anita Dix. So this is Motion 6. Motion Sequence 1. Yeah, he's paying for it. But, yeah. So, Motion Sequence 6 being Landau's motion. I mean, if the case is dismissed, I don't think Landau's motions for sanctions is going to be upheld. It's really hard to argue. I mean, technically, yeah, the motion could continue. But I don't think there's any way that he'll be held responsible. Does the real Heather S. have a case against Maddox? Not really. She's not injured by this. Unless a bunch of people started stalking her or Maddox's fans did. I mean, I guess that would be. Can Condé Nast pursue legal actions against Maddox for impersonating one of their agents? Same thing with Heather S. I don't think so, because I don't think there's any injury to them or their reputation, although maybe they could say that their reputation with Weber Shandwick is impacted by this. Why are black males only 6.5% of the population but commit over 60% of violent crimes? I think that has a lot to do with several factors, not the least of which is just a history of poverty. And I will say the crime statistic is important because it tends to be arrests, if I'm correct. The FBI statistics would be the arrest records. And so, there are lots of factors that play into this. But some of those factors do involve targeted policing, not of African Americans specifically, but of high crime areas of which African Americans would populate many of the large centers of those high crime areas due to being disproportionately impoverished versus, I guess, white people. Black males also, there is a notable lack of paternity or of, father presence, male presence in the home. I don't know how to say that in my inebriated state, but I think that factors into crime quite a bit. A cultural lack of respect for males due to a lack of presence from males. And also, we can't ignore the devastating effect that incarceration has had on the black community, and particularly from the war on drugs, with long prison sentences, which tend to breed more and more violent criminals after and as they reoffend rather than being rehabilitated. So, I mean, there's a lot of factors that go into it. I think the least important factor is some sort of racial predisposition to violent crime. I don't know that there's any study backing that up. outside of just sort of circumstantial evidence. But if you were to control for all the other factors, I don't know that it would be there. But, I'm not a statistician, so I'll leave that up to them. Does being a member of the We Was Kangs movement allow me even more rights than a sovereign citizen? Yes. Bouncing back to the Monopoly question, when Landau plays Monopoly, is he allowed to play as a car? No, he cannot. He has to play as the dog, right? There's a movie being made based on Kevin Landau. It's called Law Bud. Every dog has his day in court. How many times did you have to watch the movie Fight Club before you finally stopped finding things you missed every other time you saw it? I'm not a big fan of the movie Fight Club. I think I watched it 2 or 3 times, but I read the book, and I would strongly recommend reading the book if you haven't. I found the book to be much better at putting a logical cause behind the community that they build in the story, and it makes more sense in the book. Kenster1790, of course, I will notice you. Of course. What is a good career for a disbarred lawyer with no driver's license? Walmart. Arya says, just who in the hell do you think I am? I don't know, buddy. Can we expect a response from Munoz? Yes, we can expect a response from Munoz. They will definitely be responding to the motion. I expect it to be equally vicious. Do most lawsuits have this many witty back and forth motions? Not in my experience, although I have heard that New York tends to have a little more rowdy community of lawyers. So maybe this is more common in New York, although I still think that this particular lawsuit is unique. A lack of father figures or role models. I think that's what I said. Something like that. I have a theory. Maddox chose a real person to impersonate in the hope that a Dick Show fan would try and contact her and she'd actually get involved. That's a good theory. Very possible. And yes, I am certainly on Southern Poverty Law Center's list now. But those, they're a bunch of horrible people. Have you heard of the warrior gene? I think for the reason blacks do crime is also partially to do with genetics. Maybe. I have not done gene research. That's not my field of study. I leave that to other people who want to be hated by everybody. Will I learn lawyering if I listen to this while falling asleep? Yes. Yes, absolutely. Ladog is the iron for the irony. I did some brief research on crime for my master's, but I'm also inherently biased. Cool, buddy. What did you find out? Do you read much fiction? Any book recommendations? My go-to recommendation for fiction is Ilium and Olympus. It is a 2-part series written by Dan Simmons. And if you are a fan of fiction, historical fiction, Greek mythology, Shakespeare, philosophy, Keats, the poet Keats, and among several other works, you will really enjoy it. It's a great, great series. Ilium and Olympus by Dan Simmons. Cannot recommend them enough. Should we be expecting a similar response in cross motion from Munoz, asking for IP freely? Absolutely. What's your favorite courtroom kino? Clarify that question for me, buddy. My brain's not working on full. Is it just possible that black people are naturally violent? Wouldn't that explain their lack of being able to create countries of their own? I don't know. That's not a statement I would make, but I also have not done research. I know that some people have that hypothesis, but like I said, outside of my expertise. Did you read the book first? I think you're referring to Fight Club. No, I read the book after watching the movie. Is there ever an instance where filing an affidavit that contradicts previous admissions is a smart move? Only if you are very clear. Here's what Maddox could have done. If Maddox would have, in filing that affidavit, stated that there were some specific reasons that he did it and was very clear that he was trying to undo the possibility that the court misunderstood why they put quotes around Heather, and stating that I didn't lie, but I understand that this could be misleading and we're attempting to fix it. Had he done that, he might have avoided all of this. Might have. So, yes, the contradicting a previous admission, if done in the right way, could be a smart move, but it's always risky. Nothing significant, but targeted enforcement was a thing. Right. Yes. I think it definitely is. But I think that is such a huge problem with many factors that it'd be hard to pin down one particular cause, and that's why I'm reluctant to say so. What I will say, and this is based on personal experience, is that it is much easier to represent a white person in court than it is to represent a black person. There is prejudice in our court system. I'm not going to say that it has anything to do with racism, but there is a prejudice in policing of black people, and there is a prejudice in prosecution of black people, and it's just there. And I think if you talk to defense attorneys who have dealt with this, I would be surprised if they disagree. I would be very surprised to find disagreement there. Would sanctions that Munoz brings up be cumulative, or can he only be sanctioned once for each screw-up? Asking for a clever name here. The actual sanction does not go to another party. I believe it goes to a lawyer's fund that pays for something like... I think, it goes to something that pays for like legal aid. So that would probably be that sanction of those fees would only be one per screw up, but the attorney's fees sanctions would be individual and cumulative. Keynote means film. My favorite courtroom film has got to be My Cousin Vinny. How do magnets work? With magic and sorcery. If you haven't tried Old Putney Scotch, you should definitely try it. Many great vintages. I will look for it. Or Pulteney, not Putney. Pulteney. I will look for it, buddy. Can't do a super chat today because I had to cancel my card. Just want to let you know I love your content. Thanks, buddy. I love the views and the interactions with you guys, so I never feel bad about not doing a super chat. What did you miss? All of it. Sorry, pal. Sorry, Nels. Is there a reason Dick couldn't cover Asterios' lawyer fees due to location or something? I think it's because that would be one thing. I think the other thing is that they're competing. I've talked about this before, but they have conflicting defenses. Potentially, Dick could throw Asterios under the bus in theory, and Asterios could throw Dick under the bus in theory. So having the same attorney and paying for those fees might provide some sort of conflict of interest. Men are far more violent than women, and I'm told civilization was built by a patriarchy. That seems to be the case. Have you ever tried the Chewbacca defense? No. What's the Chewbacca defense? Like me just groaning incoherently? Can you say winners don't do drugs? I can say that. Don't have a question, ADM. Just want to give you a shout out for saying my name with the flourish a stream or two ago. Fahukwa gods. Yes. Thanks, buddy. Always appreciate seeing your name in stream. Would you ever want to be a prosecutor or an attorney for the state? Sorry if that's an insulting question. I'm not familiar with the hierarchy of respect that different lawyers have. I wanted to be a prosecutor when I got out of law school. That very quickly changed upon interacting with prosecutors. No insult to other prosecutors. I'm friends with a prosecutor not in my county, and he's a great dude, and I think he is a genuinely good actor and a good advocate for the court. However, the prosecutors I encounter on a daily basis in my practice and in and around Minnesota, I am nonplussed with, and it has completely ruined my any desire to be a prosecutor. Is the Twinkie defense a real thing? Have you ever had to plead temporary insanity? I don't know about the Twinkie defense, what that is, and no, I have not had to plead temporary insanity. If Maddox is required to pay attorney's fees, is Asterios completely off the hook, or does Asterios has to pay first and get repaid by Maddox? That is up to Asterios and his attorney. The first letters of each paragraph of Section 2 of the memo spell out something special. I think it's P, isn't it? Section 2 of the memo. Poo. Hilarious. P is also in there, by the way. I can't remember where, but if you look through it, I'm sure you'll find it. So poo and P are in there. Fantastic job, Greenberger. That is wonderful. I didn't notice the poo earlier. I did notice the P, so I'm glad that that's in there. Have you ever seen 60 Days In? No, I have not. Chewbacca defense is talking about Star Wars instead of defending your client and confusing the court into giving you a not guilty verdict. No, I don't think I have used that. Have you heard of any other lawyers offering what Landau did with the buyout for the default motion? Just how scummy is that? It's extremely scummy. I haven't heard of that actually happening. I can imagine it happening, but it's, that's crazy. That's crazy. Yeah, one, it undermines your confidence in your default motion. And two, it's like, well, if you pay us, we'll not go through with our frivolous nonsense. I had a good time playing D3 after you said I should. Good. I'm glad you did. I need to play some D3, and I just haven't had time to do it. Try Pappy Van Winkle bourbon. Hard to find, but possibly the best bourbon. I'll look for it. Thanks for the answers in stream. Peace. Later, Kenster. Thanks for joining us. From Wikipedia, the best source. Twinkie defense is a derisive label for an improbable legal defense. Okay. Would you consider reviewing Rakovsky versus the internet? I will consider reviewing anything. Send it to me in a private message and tell me. I mean, you don't have to tell me what you find interesting, but send me a link to it that I will be able to access later. These chats go away, and I don't tend to review the videos as much outside of specific things. What are the chances Bob's Burgers and Chanwick get this new motion through and Maddox prosecuted? I think the chances that they get some sort of sanction, or at least a slap down from the court. I don't know if the court is going to dismiss the action. They should. They should do that. I don't know if they'll do it because of this, but I think the chances of at least getting a stern talking to are high. What I don't know is the prosecution part will effectively be up to a district attorney to charge and determine if they could bring him in, determine if they could win the charge, and all of that. If it was in my county, I'm sure they would charge him because my prosecutors here are extremely zealous. Can you follow me back on Twitter? My handle is at #mooncult. Yeah, sure, buddy. What is the worst amendment and why is it the 16th? Because taxation is theft. Obviously. What kind of music do you typically listen to? I feel like it has been mentioned before, but I can't recall. I listen to a lot of different types of music. It really depends on what I'm in the mood for. I listen to, Broadway music. I listen to country music. I listen to Taylor Swift, who I have a special place in my heart for Taylor Swift music. You were all the way late, pal. And, I listen to metal. I'll listen to anything. That's the long and short. I will listen to whatever and just see if I can find something that I like. But I'm no longer a genre snob. I used to be. But, I like everything. But I really like my go-to happy place is 90s to early 2000s, that sort of high school and early college time when I was listening to System of a Down, The Offspring, Stone Temple Pilots being my favorite band. That's my happy place. If I was rich enough and had a lawyer and dumb enough, could I sue literally just any guy off the street for made-up reasons? Is anyone safe from this? Yes, you could. You could sue any guy off the street for made-up reasons. If you do it, obviously the court could dismiss your case and sanction you and make you compensate the person for ruining their time. Assuming worst-case scenarios with the case continuing forward, what's the first event that would require the various defendants to show up in person? I'm not sure what the court's ruling on that would be. I believe the hearing on the 27th does not require the defendants to show up in person. I think their attorneys will be there. And secretly in sync. I was not into boy bands in college, although I do have a latent appreciation for some of their music, even if only for its comedic value. What's your favorite dad joke and what's your kid's least favorite dad joke? I don't know right now. They just kind of fall out. Thoughts on baby metal? I don't have much thoughts. Sorry, I am not a Eurocuck. That is correct. And it is also not your fault. I blame my parents. Do you play any instruments? I am attempting to learn how to play piano, but no, I never played any instruments as a kid, so it is kind of an uphill battle learning it as a 36-year-old man. But we'll try. And I also do like Britney Spears. Yes, absolutely. Why is it so much easier to sue someone than defend yourself? Are there any possible solutions to this problem? No. The only solution is extremely harsh penalties for frivolous suits. Carlos Pena, what's the best Offspring album and why is it Conspiracy of One? Man, I really like Smash. I really like Smash. But Smash was one of the first albums I ever received, bought. So it's got, you know, it's right there. It's right there. Why is it? Okay, so don't forget to shill patreon.com/Asterios. Yes, go support Asterios. He's a good dude. Good choice, RE System of a Down. Favorite album from them. Was it the self-titled one with Toxicity and stuff on it? I have to go to that, although I can't really listen to it because it gives me EverQuest flashbacks because I used to listen to that while playing EverQuest. But I really did like Hypnotize and Mesmerize as well. My favorite album from STP has got to be Core. All around great. Purple being second. Number 4 would be third, which is weird. Tiny Music, I think... No, is Shangri-La-Di-Da would be 4th, and then Tiny Music 5th. Jordan Peterson's fans. I like Jordan Peterson. His fans can be frustrating at times, but, you know, everybody's fans, I guess, can be frustrating. It's not his fault. It all just depends on the context. I've met good Jordan Peterson fans. I've met a lot of new Jordan Peterson fans, and that's good. Excuse me, sir. Baby metal is Japan metal. I believe you. I don't have many thoughts on it because I don't listen to it very much. Can you quarter some soldiers in a couple private homes without the owner's consent? Asking for a friend. Privately, maybe. I guess that would be interesting. Have you ever played Path of Exile? I started to, and I didn't get into it at the time. But you know, I was really into Diablo at the time I tried playing Path of Exile. That was a problem, I think. So I don't have much opinion on it. I think it's also changed a lot since I tried to play it. Do you think that this experience will red pill the sneaky Greek into full-on Fasterios Wokenos? I hope so. Play any sports? I used to play soccer. Now I play foot golf, which is soccer golf, I guess. And play is a loose term. I also like to play actual golf. I'm not any good at it, but I like to play it. It's very relaxing, but it takes a lot of time, and I don't have time to do that. Toxicity was the album name. Perfect. Do you like Lamb of God? Lyrics go, the blood's on the wall, so you might as well just admit it very lawyerly. I haven't listened to much Lamb of God. I've heard a lot of people like them, but, you know. Excellent Call and Smash and Steal This Album was SOAD best album. Yeah, Steal This Album I didn't listen to very much, I don't think. Lit support as in iPro, Relativity, Concordance, eCapture, Lit software. List software. Oh, maybe. I don't use any of those things. My friend asked to move in with me after he leaves the army. Is he trying to violate my Third Amendment rights? Yes. You should be suspicious of anyone asking to move in with you, especially if they're a soldier. How is the heroin epidemic affecting Minnesota? It's taken several of my close friends and their family in the last couple of years, and it's weighing on me heavily lately. It seems to be affecting us in the same way that it's affecting everyone else. And there's actually a case in my town right now where someone overdosed on fentanyl, and his dealer is being charged with third-degree murder as a result of the overdose. And that to me was kind of interesting because, you know, whatever you think about drug dealers, I don't know that the drug dealer caused him to take that amount of, a too high of an amount of fentanyl and overdose and die from it. So I'm not entirely sure I agree with the third-degree murder charge, but it is in the statute that way, which, again, was surprising to me. But, that's how it goes. My question is when they're going to start looking into the origin of people's opioid addictions. I think from what I've seen, and this is all anecdotal, those opioid addictions tend to start in a clinic or hospital. And until we address that problem, I think we're gonna be dealing with the same stuff. How much booze can you get down in 18 holes? I don't drink while I golf because if I do, I would never finish because I would become a much worse golfer. Which comic has the best depiction of a legal system and why is it Judge Dredd? Well, I think the answer, res ipsa loquitur. Res ipsa loquitur. The thing speaks for itself. When was the last time you pooped your pants? I don't do that. So I don't remember. Probably when I was a kid. Dax Desi, I'm not racist. What I'm saying is the Second Amendment was written with white people in mind. Now America is a drudgy soup of terribly violent races. Would they be rolling in their graves now? I don't know. I think that many of the founders expected we would have an entirely new constitution at this point. Probably several new constitutions at this point. So. All right, guys. Well, I was going to do the Sovereign Citizen videos, but I don't have OBS set up to do that. It's been 2.5 hours, and I think it's about time to start. Winding down. Point of order. I do not know any actual Latin, just the law phrases that come about. I would like to actually learn Latin, but I don't know if I have the time to devote to something that won't overly benefit me. What was your faith's denomination? Also, can we, Dick, and friends a basic Bible study? So my faith's denomination is technically Evangelical Covenant, but, it's saying that I ascribe to that denomination's beliefs is a stretch. I am personally what many would call a deconstructing or deconstructed Christian, hopefully working on some sort of reconstruction, a la like Pete Enns or Richard Rohr, Peter Rollins. Trying to figure out outside of some of these traditions, which I think are kind of perverting the text. I'm kind of searching for that. But the church I go to is Evangelical Covenant. Dax, good night. Good night, buddy. Thanks for showing up. End on the racism. Good idea. Learn Latin for us. Okay. But if you knew Latin, you could call BS on new law phrases. Yeah. A friend of mine and I have a conspiracy to create a Latin phrase and then cite each other's legal opinions and then hopefully get that as a thing. So we'll watch for it. Dax is trying to bait me into saying racist things on camera. Man, if they're looking for me to say racist things on camera, I think they're just not looking hard enough if they don't already have it. I am certainly not a racist of any stripe. But, that's fine. Playing in a Warhammer tournament tomorrow with my Necron army. Any tips? Buddy, you'll do way better without my tips. I guess, yeah. Fuzz Got Games, thanks for joining me. Good night. All right, guys. Imagine unironically not wanting to read the Latin Vulgate. Not call BS. You could invent them. I should have learned Latin instead of the language of sneaky reds. Yes. All right, guys. I am gonna switch to the blank screen and call this a night. Thank you all for the great live stream. Thank you so much for the super chat donations. I'll get the audio up as soon as I can, but I really appreciate all of this. Greenberger, if you're out there, good job, buddy. I can't wait to meet you at some point in the future. Hope to see you all. And just as one final point of order, the Friday nights, every Friday night, plan on there being a Lawsplaining live stream. Whether there are LoLsuit documents or not, there will be other content to live stream every Friday night, and come join me for those. It will be fun. And I am hoping to do a live stream for Dankula. So if you are a Euro and you want to give me some input on what time would be good for the Count Dankula live stream, what time and day works for you guys. I know each one of you speaks for all of Europe. Please let me know in some sort of private message, and that I can kind of track. Drop me a message on Patreon, even if you're not a subscriber to me. Just send me a message and let me know what time you'd be interested, because I want to make sure we can get some content for my friends in Europe, and definitely want to include you guys in some live streams. So thanks a bunch, guys. I'm going to black out the screen because we're ending on racism, and I appreciate everything, and I will see you all soon. Have a good night.